Item number 1, 5.
When in item number 1, I'm for the respondents, private respondents.
Yes.
From 2 to 5, my lord, I'm for the appellant. I have received the paper book, my lord. Subject.
May I sign, my lord? But here, my lord, I'm in item number 1, I am for the appellant, my lord. Now, my lord, I am not sure, my lord, whether I have received the paper book or not, my lord. Even if that had been received, my lord, I have some misplaced, my lord. So I need, not sure, my lord, whether I have received or not.
Whether it is received or not.
I need to confirm that from the registry.
This is a peculiar case. So in one case, it is an appeal against acquittal.
Yes.
My lord.
In the other, it's an appeal against conviction.
My lord.
There are 15 persons were actually charge sheeted, my lord. Thereafter, 7 were discharged at the CC stage. Out of the 7 left, my lord, 3 were acquitted, 4 were.
So even though it is arising out of the same case,
Yes,
one is an appeal against acquittal.
yes.
Right.
I think this will have to be heard differently,
So it has
separately.
to be- I don't think it should be.
Yes,
lumped
it has to be
together.
heard
Acquittal
separately.
will be different.
Because it will-
and Conviction
Yes,
will be different.
Yes, it will prejudice the, my lord,
Hmm.
appellants who have been convicted.
So serial number 1 is against the
Acquittal.
acquittal,
Acquittal.
Yes,
while 2 to 5 is against the conviction,
my lord.
isn't it?
Yes.
So I don't think they should be listed together
Yes, they
because
should
the
not.
issue will be completely different.
Yes, exactly, my lord. Because it will prejudice also the, my lord, appellant who have been convicted.
So in item number 1, you are the counsel for the appellant,
Respondent.
for the
Private.
respondent. And who's the appellant? Appellant is the,
Me, respondent.
okay.
Wife
Appellant
of the
is
deceased person.
affected family.
My lord.
Yes.
What about 2, 3, 4, and 5?
2, 3,
They
4,
are
I am for the respondent.
representing the wife of the 2 deceased persons.
So I think we should again list them separately.
One
Should we?
separate,
Ah.
2 to 5.
2 to 5 my lord
Five.
to be heard.
Third, Mr.
L
For
for
the
El
appellant.
permit.
El Pame, learned counsel for the appellant, along with Mr. Dicky Pange, learned counsel for the respondent,
private respondent.
the private respondent.
I'm posted.
While Mr.
Jita
G. Taru appears on behalf of a learned additional PP or PP?
Yes, additional addition.
Additional PP appears on behalf of the state respondents. The learned counsel submit that they have received the paper books.
I have, my lord.
My lord, I am not sure, my lord, I have whether I have received
Okay.
only.
You have not received.
Not sure, my lord, I need to,
You should be sure you come today.
in my file, that is not there, my lord, but
You-
I need
you
to confirm
are
from the
the
registry, my
appellant,
lord.
So you should have received.
Right.
If not, you take steps.
My lord.
The learned counsels for the party submit that paper book is ready and this matter may be listed for hearing
Hearing.
in due course. It is also seen that this matter has been listed along with items number along with criminal appeal number 2/2022, criminal appeal number 3/2022, 4 and 5/2022. However, it is seen that the other criminal appeals is against the conviction of the appellants. In view of the above, the criminal appeals 2, 3, 4, and 5 okay, are to be segregated from criminal appeal number 10/2022.
Ma'am.
Yes. Now, from 2 to 5, who is appearing?
My lord, I'm appearing for the appellant.
Okay,
The paper book I have got.
I am for private respondent. I am for the victim.
then Mr. D. Pangi, learned counsel for the appellant, is present along with Mr.
El
Parveen,
permit.
learned counsel for private respondent, and Mr.
Again, I'm
Srivastava,
posted.
learned
Okay.
additional PP. It's seen that paper books are received and items, the criminal appeals 2, 3, 4, 5 being arising, since they are arising out of the same judgment and order, should be clubbed together and listed for hearing in due course.
Right. So,
Okay.
Item number 3.
Lordship, in this matter, the appellant are regular ASI of civil police. Presently, they are working as SI on officiating basis. Their regular appointment in the post of SI Civil Police is due as they have completed 6 years continuous service as SI on the officiating basis. They are entitled to regularize in their respective posts under Article 309 of the Constitution of India. The appellant filed a writ petition before this
You're
honorable
reading, you're
High
reading
Court.
from where?
It's,
You're reading a synopsis
no,
or your notes?
I just point out the main.
Ah, okay. So this is an appeal against the judgment and order
Yes,
of the learned single judge in,
With petition number, page 36.
before it was dismissed.
dated 18/05/2023.
Yes.
Written. So will you show notice, has notice been issued?
We can do.
Your Honor, our lordship,
Yes. Yes, yes, yes. But
lordship,
who is
the
appearing for the respondent?
respondent or authority, they didn't file the affidavit.
See, their ground is that the respondents, that the state did not file the objection in the writ petition.
In writ petition, yes.
They did not file any objection in the writ petition. So are you going to give them retrospective
Lordship, we are
promotion
going
or
to
no?
file- We'll be
If the
filing,
state-
No, why should we?
we'll be filing,
Huh?
we'll be filing.
No, Lordship is asking whether you are willing to give them retrospective effect of promotion.
Because in the
No.
WPC,
No, no.
you did not file any objection.
Correct, Lordship. Because that was before our filing law. The matter was taken up, Lordship, and.
Okay, saying that you have no.
It was not Lordship, we Lordship, in that, in before single bench, we Lordship refused to file Lordship.
Okay.
But
Okay,
before it was Lordship, filed Lordship, matter was disposed.
okay, at motion, that the motion stage is
Not
that-
in motion, it's still Lordship,
Somewhat later.
not in motion.
Okay.
Writ
Parties were heard. You see, since they had not filed their written objection,
Let them.
we'll give them a chance. What is their state, because we don't know.
We don't know. We might not wait too much.
Lordship, it may fix for hearing.
No, we'll,
It has to be admitted. then-
yes, I think we'll admit the appeal since you had no stay, you had no say before in the writ petition. So we'll admit the appeal, then let's hear your ground, because now the court is under the impression, since you have not objected, that you look willing to give the retrospective promotion. So we'll have to hear them also.
Right.
I think that will be okay.
Fine.
We will admit the appeal. Heard, Miss
Dirilung,
Dilung.
Rilung.
Okay,
Really?
you give your this thing, learned counsel for the appellant along with Mr.
Has Tapin,
Yes,
with
Tapin.
India government.
All the-
Senior Government
For all the-
Counsel for the respondents. This is an appeal against the judgment and order
18/5/23.
okay, dated 18/5/2023, passed by the learned single judge in WPC number 235/2023. Wherein the learned single judge had held that, had dismissed the writ petition on being found of being devoid of merit. It is noted that in the said writ petition, the state respondents had not filed any written objection. And the learned senior government advocate submits that they may be heard in this matter. In view of the above,
Hearing,
admit the appeal,
hearing.
list the matter for hearing in due course or after 2 weeks.
3
After 1
weeks.
week?
After
3 weeks, Lordship.
After 3 weeks.
The meantime,
Yeah.
In the meantime, also we will be filing.
just observe that in the meantime, the state respondents can file their counter. So,
But this is an appeal. You want to file any counter? In the meantime, the state respondents may file their counter affidavit if so advised.
No.
Yes.
The copy would be required, extra copy.
Uh, Requisite extra copies of the writ appeal to be duly furnished to the learned, to the state respondents. List after 3 weeks.
Item number 7.
Yes.
Malad, here, will file affidavit, Malad. 4 weeks time will be granted, Malad. In the meantime, we will file affidavit. GST matter, Malad.
My lord, so far, my
GST
lord,
matters, huh?
yes, my
Coming
lord,
up now. People are waking up. And coming, quite a few of them. Yes.
my lord, so far, respond number 2 and 4 is concerned, my lord. 2 is chief secretary and number 4 is from commissioner, my lord. We have nothing to do with the this either in the impugned notice issued by the assistant commissioner nor the GST, my lord. So may I ask, my lord, the respond number 2 and 4 may be strike off, my lord.
No, my lord.
Yes.
Since
Well,
my
okay.
Nothing to do.
Let them say, my lord, they are not necessary, but that's it, ma'am. At least they have to file.
No, file, how can we file for the central, it's this what you call GST, my lord? It's a central act, my lord. We have nothing to do, my lord.
So why
Even
haven't
the
you
impugn
why
authorization
haven't
should
you
be-
made them a party?
Chief secretary, I don't know why.
On what grounds, let's say? What is there?
Nothing.
There is nothing, my lord.
Nothing.
Evidently, Malad, they are not necessary, but.
No, that's all, my lord.
Because it's a normal thing to add them, that's why you've added, or in your.
No, my lord, actually, the
petition.
thing is that I am the local councilman.
Hmm.
Yeah, the leading council is.
It was all drafted somewhere else and it was sent to my brother and
Okay, so
Okay.
you're
Mr. Venkata Prasad.
the leading council.
Yes, I'm the local council.
Then we'll see in the next date,
Yes, ma'am.
we'll mention your submission.
My lord.
Okay.
My lord, in this case, I'm appearing for response number
Mr.
3506.
Your good name, please?
BP Chairman.
BP Chowdhury appears on behalf of the petitioners and submit that, appears on behalf of the leading counsel, Mr.
My name is Dear, my lord.
He's there, my lord.
Okay, Mr. So-and-so appears on behalf of the petitioners while, Mr.
Arachna, my lord, for
Arachna,
respondent,
ma'am.
24, my lord.
For
Yes.
response number 2 and
appears on behalf of Mr. M.
Four also, my lord, the address is not proper. There is no such.
M. Taku
for response number 1,
appears on behalf of respondents number 1, 3.
1 and
Malad, I am for 1, 3, 5, and 6, Malad.
1, 3,
Okay,
5.
appears on behalf of respondents number 1, 3, 5, and 6, while Mr. R.H. Nabang, learned additional AG, appears on behalf of respondents number
2 and
2
2 and
and
4.
4. The learned additional AG submits that the names may be, the names of respondents number 2 and 4 may be struck off since they have nothing to with regards to the instant case. However, the learned counsel for the petitioner submits that this matter may be considered in the next date since the leading counsel, Mr.
P. Prasad, ma'am. Venkata Prasad.
P. So-and-so is not able to appear today. Then Mr. M. Kato, learned counsel for respondents number 1, 3, 5, and 6 has prayed for further time to file the counter affidavit. In view of the above, list after
4 weeks.
4 weeks.
Leave them.
Item number 6.
Clothing of the petition. Subs. I don't find them on the forensic report. Forensic report. That's it.
Anyways,
May I please, your lordships? In fact, this is a criminal appeal. We are challenging the judgment and order dated 21/6/2021. This is the, yes,
you to file an PIL.
Yes,
Something
Lordship,
happened.
there is already provision that through the FIR that State Act can be challenged. That
No.
once in Assam, that Parliamentary Legislative Assembly 2004 was challenged and struck down through the FIR, Lordship. Lordship, FIAL, it is completely based on public interest litigation. Lordship, Lordship, that I am challenging the whole act, Lordship.
You're challenging the
Yes,
whole
yes,
act,
whole act,
itself,
Lordship.
not any specific provision
Oh,
of the
Lordship,
act.
Lordship. Lordship, before going to my submission,
At this point, you can argue the repugnancy. This is under the concurrent lens.
So now both of us have single benches,
Lordship,
and we have just heard a case hearing. Now, if there is no urgency in the matter, maybe we can adjourn the matter for some other day.
Lordship, that may be on tomorrow, either day after tomorrow, Lordship. There has been so many adjournment, and I have pressure from my client as well, Lordship.
Just one thing can I ask?
Please go ahead.
Mr. Chaudhary, the only point he may have in the whole gamut, the power is with you. The entry is there. Similar acts have been made in Assam also, in Gujarat also. The only question he may have is that this act being in conflict with the central act, or
Exactly, Lordship.
precisely, was it not required for you to take a presidential accent in the matter?
Those issues would be touching upon the merits. I would say that this PIL is not maintainable on several counts.
Let us, he has brought in something. So the question of repugnancy would be the only issue, which would now be
That is not expressly even clear.
that he can develop that argument while arguing.
Okay.
Because in your counter also you have not gone deep into that issue.
Because your lordship also noticed the pleading.
We are on the issue. We have forgotten it's a PIL. Otherwise, not a
Unless it is expressly pointed out that this particular provision.
because they have.
What I want is your lordship's query. Unless it is expressly pleaded that so and so provision is repugnant to this act.
No, the very fact that what I've understood is he's trying to say that you can bring it into operation, but you will have to have a presidential assent.
Exactly,
Here,
Lordship.
only the assent of the governor has been taken. The Assam Act, it went up to the president.
Yes.
The assent was taken. So examine that today. We examine that issue. You also develop your case.
Yeah, Lordship, I've already mentioned that consistency is
Mentioning will not do. You
Already-
will have to bring on record judgments.
Yes, Lordship, I have.
254.
Yes, Lordship, that's 254.
So you come prepared with all those points?
Okay. Mr. Chaudhary, you also examined that issue.
Lordship, having some kind of.
You see, because if it appears that the nature in which it has been the filed, the PIL, I think it's mainly on those grounds that your counter is on those grounds. You have not really touched upon the merits. You have not really touched upon the merits of the case.
One aspect perhaps which at the very outset, my learned man will have to satisfy. There is a very clear judgment of the apex court that by way of PIL you cannot put to challenge an act.
Now, Lordship,
And there is no pleading to the effect that these are the kind of persons who would be affected and people who have been affected, why they didn't come. All these aspects are not even there.
Whether this PIL is
Lordship,
maintainable in its present form and
Exactly.
style, I think that's the first issue that we have to look into in this.
Lordship, I have judgment of this one judgment that through the PIL that
When do we fix it for?
He wants it in August. Any
Okay.
date, Mr.
I will have to be here for the Independence Day. So it's a
14. Fine.
let's 14 August.
14 August.
Mr. So and so, both of them are present, okay? List on 14.
But
This is an important issue, it takes
it
time.
has
we
come
have
to
look.
our notice. Address the court on that also.
Yes.
Lordship, I would like to mention item number 20. Your Lordship, here I have to file affidavit, Your Lordship. 2 weeks' time may be granted, Your Lordship. I have taken the consent of the petitioner. Item 20.
See, I don't know what is the system out here. But when you pray for adjournments out of time, praying for time,
Lordship,
out of what it's been listed. Okay, out of turn, you're praying for time,
No.
saying I have to do this. Then shouldn't you wait for the matter to be called? And adjournments will be concerning the supplementary hearings that have been listed. That we can adjourn straight away if you're not going to have hearing. Otherwise, there's this long line queue. And your prayer will be the same. The council is absent, this. So you wait for your turn, we'll call.
Lordship.
Isn't it? And we'll see, now you're also saying that you have to file your, affidavit or counter affidavit.
Yes.
So let the matter come up, then we'll see.
Lordship.
But if there are any supplementary hearings which are to be adjourned for today, that we will see. There is sort of a queue being made here, or whoever comes first reaches this thing first will mention the matter. Wait for your turn. Supplementary hearings, are we going to have any hearings today or adjournments?
Well, no, sir. I beg to mention item number 32, the
32.
supplementary hearing. My senior counsel is out of station. Matter may be listed after 2 weeks.
Here, Your Lordship, I'm appearing for respondent number 2. As LIC, my name may be reflected in the cause list.
Okay, mention is made on behalf of Mr.
M. Lago,
M. Nabo, learned counsel for the appellant for adjournment of the matter. Miss
Enanju,
Enakjo submits that she is appearing for respondent number 2 and that
As
her
LIC.
name may be reflected in the cause list. Registry to do the needful. List after 2 weeks.
obliged.
of last month.
Lordship, item number 21 is supplementary hearing, Lordship.
20,
29, Lordship.
29.
Yes, Lordship.
Yes,
And this may be fixed after, Lordship, 4 weeks. I have taken permission. That 4 weeks.
4 weeks.
Yes,
Okay.
Lordship.
Mr.
G. Kata, Lordship.
G.
Kata.
Carton. Is it? Learned counsel for the appellant with the consent of the respondents have prayed for adjournment of the matter. In view of the above, list after 4 weeks.
Yes, Lordship.
Right, please, Lordship. Lordship, I beg to mention item number 33. It's supplementary hearing.
33-0,
33.
33.
Yes.
Okay. Huh.
I on behalf of K. Bogo, conducting counsel, Mr. K. Bogo is out of station.
Mention is made on behalf of Mr.
K. Bogo.
K. Lolin.
K. Bogo.
Okay. K. Bogo.
Yes.
Learned counsel for the petitioner for adjournment of the matter, which is not objected by Mr.
Jitado, for
G.
state.
Tago, learned TP for the state respondents. In view of the above, list after
3 weeks. Lordship.
3 weeks.
Deeply obliged.
May I please, my lord? I beg to mention item number 31. My lord, consent has been taken. I may pray for matter may be listed after 3 weeks.
Okay. Mr.
D. Bangu.
T. Damu, is your name here in the cause list? Yes, no.
No, my lord.
Okay.
I'm
Mention
appearing on.
is made on behalf of Mr.
Oh, Father.
O. Pado, learned counsel for the appellant for adjournment of the matter. Oh, you are for the respondent.
Yes, my lord.
Mention is made on behalf of Mr. O. Pada, learned counsel for the respondent for adjournment of the matter with the consent of the appellants. In view of the above, list after 3 weeks.
Yes, my lord, 3 weeks.
3 weeks.
My lord, I would like to mention item number 30, my lord, 30.
You're for the appellant?
Yes, my lord.
Hmm.
Here, the parties, they are trying to settle the dispute outside the court. So we need some more time.
Okay,
The
Mr.
matter may be listed after 3 weeks, Your Honor.
Mr.
T. Darge. I'm on behalf of Senior Counsel R.
P.
Sonar.
Darge, appearing on behalf of Mr.
R. Sonar, Your Honor.
R. Sonam, learned senior counsel for the appellant, that the parties are making an attempt to come to an amicable settlement outside court and has prayed for listing of the matter after
3 weeks.
3 weeks. In view of the above, list after 3 weeks.
God bless you.
May please, my lord. My lord, I beg to mention item number 9, my lord.
9.
Item number 9.
You wait for your turn. This
Yes,
is-
my lord.
You wait for
We
your
taken
turn.
consent from the applicant, my lord. I am for the respondent.
9. What
Item
is the
number-
stage? 9. What stage is it?
Mm,
What are you supposed to do in item number 9?
Admission in admission.
Hmm. What are you supposed to do?
My
See,
lord.
we'll have to see the file. So you wait.
No.
What? No,
Yes, my lord.
you don't want to see the file. Okay, you are Mr.
And Sora.
Mr. M. Saurabh. Appearing on behalf of Mr.
My name is Dion.
Okay, learned counsel for the
Respondent.
respondent.
Yes, ma'am.
With the consent of the petitioners have prayed for adjournment of the matter. In view of the above, list after
3 weeks, my lord.
3 weeks.
The flu days.
Any more supplementary hearing matters to be mentioned? Yes.
Item number 1.
Lordship, 439 application in connection with session case number 02/2021 arising out of boundary of case number 22/2020. The accused person behind the bar since 10/11/2020 and today is 1,351 days and accordingly 3 years, 8 months and 51 days. Lordship. Kindly call for the LCR, fix another date for bail hearing.
Well, this is a bail application, so
Lordship. Bail application is under section 30, allegation under section 302, 120B, 216, and 316.
okay. So what is the stage of the case now?
Evidence, Lordship. Out
Evidence.
of 32 witnesses, till date, 6 witnesses already.
Okay, so how many days has he been in prison?
Lordship.
For how many days has he been in judicial custody?
And
Trial?
3 years, 8 months and 11 days.
3 years.
8 months and 11 days today.
Anyway, heard Mr.
G. Pokan.
G. Phokan, learned counsel for the applicant, who has filed the instant application under section 439 of the Code of Criminal Procedure for grant of bail to the appellant/accused, who was arrested on 10/11/2020. The learned counsel submits that the instant applicant has been in judicial custody for a period of over 3 months during the pendency of the trial.
3 years, 8 months.
Oh, 3 years, 8 months
And 11 days today.
and 11 days during the pendency of the trial wherein he has been charged under section 120 within brackets B/201/302/316 of the Indian Penal Code in a case registered against him in session case number 02/2021 arising out of
Bandar Deva.
Bandar Deva PS case number 22/2020. Issue notice to the respondents, Mr. So-and-so. Learned additional PP accepts notice on behalf of the state respondents. No need to issue a formal notice. Requisite extra copies of the application to be duly furnished to the One additional PP list
After 2 weeks.
after 2 weeks.
Scan copy of LCR may be called.
Pardon?
Scan copy of LCR.
Meanwhile, LCR,
Scan copy.
Session 40
scanned
PM.
copy of the LCR is to be called for.
Published.
This matter may not relates to suspension. The suspension order was put under challenge. And I have been told that they are going to take time to file affidavit. Continue.
So are we going to hear the ground of maintainability on next date?
My lord, in that we can read back, this maintainability issue can be remain open, keep it open. We can read that part also. In that case,
First of all, they are supposed
Okay,
to
we
file-
should
affidavit.
accept a copy first, isn't it?
Because I have challenged the suspension order.
Hmm.
And now they are saying petition is not maintainable. First of all, let them file an affidavit. On what ground it's not maintainable?
Let's see the synopsis under what you have challenged your suspension, and why were you
Yeah.
suspended?
Suspended from, my lord, my existing service as, my lord, BO, Block Education Officer. Allegation is that, my lord, I facilitated the government, my lord, department to file affidavit in connection with other cases, while I was serving as a nodal officer. Now they are supposed to file affidavit, my lord, at least to know what is the reason. I submitted my reply, they didn't bother even to, my lord, even to go into my reply. Then they, my lord, issued, my lord, Shocker's notice, article of charge. I was directed to submit my reply. I have challenged the, my lord, charge sheet. This article of charges by filing another petition. It is also listed today.
my lord, in this case,
And on the last occasion, my lord, they took time to file affidavit.
See, this court's last order, it says that the maintainability of your writ petition will be looked into, and that the state respondents were to receive instructions. And the question was on the maintainability of your writ petition, which is challenging your suspension order, you said, is it?
my
So
lord, here
disciplinary action was initiated against you.
initiated, my lord.
So before the disciplinary proceedings is complete, he
No,
has filed the
My lord,
petition.
here what happened, my lord, to initiate the disciplinary proceeding, my lord, the memorandum of charges were served upon the petitioner.
Oh,
Now petitioner, they come up with the petition challenging these memorandum article of charges
oh.
instead of contesting departmental proceeding before the authority, my lord. That is why this penalty has been issued, my lord. Because always the writ code, my lord, 226 can be always have a power, my lord, to examine the reasonability, the after the order is passed, my lord. Now when, if there's no any the substance in the charge, my lord,
Article of charge has not been,
it has been, my lord, this is the subject matter of challenge here, my lord. 175 in the writ petition, my lord, there's an article of charge already served, my lord. If he's innocent and the allegation article charges is not based on any valid reason, he can stand, my lord, in this departmental proceeding, my lord. Why this
which
226?
is not completed yet.
My lord, yes, my lord.
It's
That is
an
why, my lord.
Initial stage.
My lord, other days, my lord, on the first day of motion, my lord, I apprised the court that motion raised whether, my lord, is subject to any writ jurisdiction. Then I apprised the court that there are a number of decisions on this point. It is altogether not a bar. There is no any legal impediment to challenge the, my lord, article of charge. Because if
Anyway,
you,
at this stage,
therefore, my lord,
the
once-
question of maintainability will
Yes,
be
my
kept
lord.
open. You receive a copy first. You have not received it.
My lord,
It appears, or you have been served copy of the writ petition?
My
Not
lord,
yet.
my lord, at the filing, my lord, only the the for a step, my lord, they have not served the copy.
Not served yet, so copy be served first and then
My lord,
your
my lord.
maintainability will be looked into.
My
We
lord,
get
let the
to-
party be asked to furnish the
Yes,
step,
yes.
copy for.
At this stage, deciding that, I don't think. it will be
Regarding which
possible.
one, which one?
Yes, heard,
Two copy did
Mr. Is it Gautam Phukan? Learned counsel, is heard Mr. So-and-so, learned counsel for the petitioner. Along with Mr. T. Dagum, learned standing counsel
Education, madam.
for Education Department. It is seen in the court's order dated 07/06/2024 that the learned counsel for the respondent was to obtain instruction regarding the maintainability of the instant writ petition. Having heard the submissions made by the
May I
learned
just verify, my
counsels
lord?
for both the parties,
May I just,
this
my lord,
court
point?
finds that the question of maintainability will be kept open. Meanwhile, the instant writ petition, which is challenging the show cause notice,
My lord, charge sheet. madam.
okay, is with regard to the charge. With regards to the charge sheet, made out against the petitioner.
Wait, na, wait, no.
It is with regard to the impugned article of charges within the brackets, charge of misconduct. Okay. Issued to the petitioner.
Well, there is some confusion, I think, my lord.
Hmm.
Maintainability question raised in so far as my lord, item number 27 is concerned. Not in respect of this item. This is
My
the
lord,
matter
this
related.
And whether the charge sheet and that the charge sheet is not based on any substantial, substantive materials. To establish the existence of any such charge of misconduct against the petitioner. Notice be issued to the respondents, Mr. So-and-so accepts notice on behalf of the
Respondent 1
respondents
4.
number 1, 3, and 4.
and 2, the commissioner, they have implemented arrest as impersonal.
So who is appearing for the other respondents? Respondent number 2.
2, my lord, this is private, since they have implemented in name, my lord. So the step is required to be taken, man.
Okay, steps to be taken for issuance of
already we have
notice
taken, madam.
upon the respondent number 2. See, respondent number 2, it's not as a department. Let's see, we have implemented respondent number 2 as a private respondent.
Yes.
So steps to be taken for issuance of notice upon the private respondent number 2 through registered post with AD within 3 days, returnable by 3 weeks,
My lord.
less after 3 weeks. Meanwhile, requisite extra copies of the writ petition to be duly furnished to the learned standing counsel for Education Department. Yes,
My lord, this order will cover my item number 27.
It's connected, my lord. At number
Correct.
27 is also.
okay,
there, my lord.
27.
Yes. Both the matter will tack together, my lord.
The learned counsel for the petitioner, okay, submits that this matter be listed along with WPC number
WBC number 122.
122 of 2024 at number 27.
item number 27. 122.
Yes.
122 of
WPC 122/2024.
Yes.
Since both the matters are similar. In view of the above. The
May I present, my
instead
lord?
writ petition is to be clubbed together with WPC number 122/2024 and listed after 3
My lord,
weeks.
Lordship may kindly fix the matter on 23rd of August one.
23rd of August,
August.
okay, and list the matter as prayed for on 23rd August 2024.
My lord.
Yes,
God bless you.
so we'll have to note item number 27 is also 23rd August. Yes,
Deeply obliged.
yes.
Lordship, may I please. Lordship, this is a joint petition. All the petitioners are contingency staff of animal attendant of biological park Itanagar. And this similar matter has already been decided by the Honorable Court. Why the WPC number 361/2006 similar matter where 22 petitioners filed writ petition before this Honorable Court praying for regularization of their service. Accordingly, on the strength of order passed by this Honorable Court, order dated 12/9/2007.
Where are you referring to? Page?
Page number 37.
Same department?
Yes, same department.
Contingent animal attendant.
Yes. page
Now, in your
37.
case also contingent animal attendant.
Yes.
Okay.
On the strength of order passed by this Honorable Court, 23 animal attendant got regularized, and out of the 24 employee, 4 person have been elevated to forest guard, and now their post 6 posts is lying vacant. Accordingly, this 4 petitioner filed application before the curator biological park and thereafter director biological park Itanagar, and representation submitted before the respondent authority number 1, the PCC of Itanagar. The PCC of Itanagar is keep pending the representation.
Okay, where's the representation dated?
My application representation page number 49 onwards. Page number 49, dated 13 June 2023.
13 June 2023. So
Yes.
this has not been attended to.
Yes, same.
Till date, no response.
No response.
So you have come to this court.
Yes.
So can we dispose of the writ petition with a direction that they should attend to the, isn't it? Yes, who's for the state? Yes.
And the curator biological part also forwarded my application before the director biological. Again, the director biological part forward my application before the respondent of the PCCF. But the PCCF respondent 1 is reluctant to respond my representation.
Okay. Yes, heard, Mr. Your good name, please, Mr. Spencer. Learned counsel for the petitioner who has filed this instant petition under Article 226 of the Constitution of India for issuance of the appropriate writ or for an order for the regularization of the service of the petitioners who are serving as contingent animal attendants to regular and animal attendants at the biological park, Itanagar, against the existent available vacancy post as per the recommendation letter submitted by the respondent number 2 / who's respondent number 2?
2 and 3. 2 is director biological park. 3 is curator, who is the caretaker of the
Respondent number 2 and 3 before the respondent number 1, who is the principal Chief Conservation of Forest, Department of Environment, Forest and Climate Change, Government of Arunachal Pradesh, Itanagar. The Learned Counsel for the petitioner submits that the petitioners have been working as contingent animal attendant at Biological Park, Itanagar for the last, how many years?
14 years, 4 years to 14 years. Petition number
For
one
the
is
last
14 years.
4 years to 14 years.
Yes.
Without break in service. Without break in service till date. There is a confusion. That the post of contingent animal attendant is now instead of the post 6 numbers, okay, that 6 numbers of the post of regular animal attendant are now lying vacant in the department. And as such, the petitioners have made their representation, which is dated 13th June 2023, for the regularization of their service as animal attendant. The Learned Counsel submits that a coordinate bench of this court in a similar matter in WPC number 361, is it within brackets AP 2006, dated, what is the date?
12/9/2007.
Huh? 12/9?
12/9.
12/9/2007. Had regularized the services of similar situated persons. However, till date, the respondents have not attended to the representations made by them before the respondent number 1. The Learned Counsel submits that the instant writ petition is limited to the prayer that the representations made by the petitioners before the respondent number 1 for the regularization of their services may be attended to. Full stop. Miss
Arbasar.
So and so, learned government advocate for the state respondents makes appearance and submits that since the instant writ petition is limited to the prayer that the representation made by the petitioners be considered and disposed of by the respondents. She has no objection to the prayer made by the Learned Counsel for the petitioner in the instant writ petition.
Some they have submitted their representation on 14 also, Your Lordship. They have submitted different applications, not the same.
Okay.
Jointly, they have not.
The representations, we will just make it instead of the date, the representations made by the petitioners before the respondent number 1 during the year 2023. Leave it at that. having heard the submissions made by the learned counsels for both the parties, and considering the limited prayer which is made by the learned counsel for the petitioner, this court find it fit to dispose of the instant writ petition with a direction to the respondents, okay, to consider and dispose of the instant to consider and dispose of the representations made by the petitioners for the regularization of their service on due to the resultant vacancy of the instant post within a period of
Within a month,
uh,
Lordship.
3 months,
Lordship.
within a period of 3 months. Accordingly, the instant writ petition stands disposed within a period of 3 months from receiving the certified true copy of the instant order. Accordingly, writ petition so and so stands disposed of as above.
Highly organized.
Item number 4.
Item number 4, madam, we have filed affidavit in reply affidavit. And it is not on record, my lord, they have received the copy.
My lord, at number 4.
Yes.
Not yet filed.
What?
At number,
Affidavit and reply, not
Affidavit.
file. Yes.
My lord, we have already filed, my lord, but that was not formally accepted till now, but they have received the copy.
my lord,
There is some
may
technical-
may I clarify my?
Just clarify.
My lord, in this case, I filed the affidavit, my lord, on June 2024, 4th June 2024. Here they required to file the rejoinder. In other case, they filed, in connected similar case, in other case, my lord, they filed.
Okay, so yes, so here,
Here they required to file. Item number, my lord, this is since name is similar, that's why they're getting confused, my lord. At number 11, they filed the rejoinder.
so does he
I
know,
received-
does he know that they have filed their rejoinder in the other?
Man, that's why that is why there's confusion, man. He's
Okay.
instead of this 11, understood as
Yes, sir. He is right, ma'am.
Yes, so now we are dealing with item number 4,
item
which is
number 4, madam.
WPC 363.
I-
Now, in WPC 363, you have to find your
Madam,
rejoinder affidavit or affidavit
I
in
need some
reply.
time, madam.
Oh, so you need some time.
Yes.
Yes.
By the time, my lord, lordship fix the matter.
Mr. So and so, learned counsel for the petitioner has prayed for further time to file his affidavit in reply.
Because both the matter connected, madam.
In view of the above, list after, how long will it take?
My lord, or lordship fix the matter on 23rd, by that time I will.
In view of the above, list this matter on 23rd.
and
Yes, August 2023.
And by that time I will.
Yes, by 23rd, you should have filed your affidavit in reply. Yes, finish.
man, he's requesting
Fine.
at number 11 as well. 11 is together, man,
Okay.
similar.
The learned counsel for the petition further submits that
11 I file affidavit.
WPC number 73/2023 is with regards to a similar matter and that both the matters may be clubbed together.
Yes, in that case, I have filed affidavit, reply affidavit.
Registry to do the needful, list both the matters on 23rd, 8, 2020.
And lordship kindly make an observation that we have filed rejoinder affidavit. In
That will
connection-
be there in the file.
My-
It's
So
all.
for
it's
this
there.
one, you file.
My-
Okay.
This all. this.
Lordship, here we need some time to file affidavit, your lordship. 2 weeks may be granted. Lordship, I'll just place one thing before lordship, because they have to take instruction on this if they're filing affidavit. Lordship, I have challenged the interim order passed by an arbitrator. They have rejected my interim application. Now, lordship, the arbitrator has resigned. So whether once the arbitrator has resigned, his interim order will be, lordship,
Interim orders in existence, it has to be.
vacated. That's it. So they
So
may
it
take
has to be
instruction if they
vacated,
file
whether
an
it's the
affidavit.
same arbitrator, not so have they appointed a fresh arbitrator?
Not yet.
Not yet.
Yes, your lordship. I'm giving a
So-
copy to them, lordship.
What is this?
No, so this is a resignation from the arbitrator.
Okay. So he has resigned,
He has
but his order is still there, written order, so
That has to be set
be
aside.
vacated if
Yes.
you're, that's what you want, isn't it?
Yes, Your Lordship, that's the only case.
Third, Miss
And Haveli, Your Lordship.
Anne Havelia, learned counsel for the appellant,
I'll bring this on record by way of filing
Okay.
an additional affidavit.
who has stated that the instant arbitrator has resigned. See, this was also already observed by this court in the last court date.
Lordship. The
And-
matter was noted.
Has submitted. I think this should be in by way of an affidavit.
Last time I did not, I will bring it on the record by
Okay,
way of.
and
affidavit.
submit
Last time it
that
was not there
should
with me.
be bringing the resignation of the arbitrator on record by way of an affidavit. In view of the above, list after,
Lordship, on 2nd of September.
okay, in view of the above, as prayed for, list on 2nd September 2020.
So they may also obtain instruction.
Lordship. In the meantime, a copy has been reserved. In the meantime, huh?
Yeah, I've given the copy.
Okay. In the meantime, the learned counsel for the respondents is to file their counter affidavit. Lordship.
Much obliged. Yes.
Okay. Yes, we'll meet again at 2. Yes.
Mayor, Lordship, conducting counsel in this matter, Mr. Ada, within the brief. Hello.
You are for the
I'm for the respondent,
sole respondent?
sole respondent.
Yes, you were absent for how many times? Three to four consecutive court dates. So
Lordship,
now finally you're present.
yes, Your Lordship, I was engaged in local council and there was miscommunication between the
Okay.
conducting council.
So what is the stage? Where's the counsel for the petitioner?
Petitioner M. Kato was there. And I have instructed to fix this matter on 29.
Okay. Mr.
J. Karba.
J. So-and-so, learned counsel for the sole respondent is present and submits that this matter may be listed on,
29 of this month, July.
okay, 29th August 2024. None appeared for the petitioner.
Sorry, Your Lordship, July, 29 July.
Okay, for 29 July. Where's the counsel for the petitioner?
Yes, Your Lordship.
The counsel for the petitioner. Any idea?
Yeah, Kato sir was here this morning. I don't know.
None appeared for the petitioner. No. In view of the book list as paid for on 29 July 2024. Yes.
My lord,
Yes.
during the pendency of this matter, my lord, this petition, the party has resolved the matter amicably outside the court, my lord.
Oh, really?
I've been instructed to withdraw this matter as not fresh, my lord. At
Yes.
number 7.
Okay, very good. Mr.
T. Tagum, my
T.
lord.
Tagum,
Tagum.
learned counsel for the petitioner submits that during the pendency of the instant arbitration petition, the parties have come to an amicable settlement and that he wishes to withdraw the instant arbitration petition. In view of the above, the instant arbitration petition stands disposed of on withdrawal.
Withdraw. Deeply up.
Yes.
Lordship, and earlier order, Honorable Mr. Justice Kaushik Goswami has
Mhm.
ordered verbally for payment deposit 50% decree awarded amount. So like my client is he's praying some more time to deposit the amount.
Verbal order, it's not here in writing.
It is not reflected in order. So
Ah.
yeah, this this may be reflected in order copy.
But since it's not reflected here.
Your Worship, I am for respondents.
Uh-huh.
And the earlier occasion,
Uh,
Honorable Mr. Justice
Yes,
Devashish Shekhia,
uh,
the speaking order directed the appellant to deposit the 50% amount of the amount involved in the case.
Okay,
And
so you have prayed for further time.
yes, but the said order would not left out to be mentioned in the order sheet.
Yes, it's not
And
mentioned. That's
yes,
why.
yes, ma'am. Yes, Your Lordship. And thereafter, they obtained several adjournments for deposit the same.
Okay.
So that
We'll
order,
reflect it- we'll reflect it here.
Yeah.
yes,
Okay, so that.
so that order may be reflected in the order
Yes,
sheet.
yes. Heard, Miss
D. Rilung,
D. Duling, learned counsel for the
petitioner.
appellant.
Yeah.
Appellant, along with Mr.
A.K. Misra,
A.K. Mishra, learned counsel for the sole respondent. The learned counsel for the appellant submits that they were instructed by this court to deposit 50% of the decretal amount
Yes.
yes.
into the court. However, since the appellant is facing some difficulties, she has prayed for further time for depositing 50% of the decretal amount. What is the amount?
Total amount.
30 lakhs the principal amount and 1 lakhs compensation with an interest 12% per annum.
So how much are you supposed to deposit?
So about
15 lakhs.
about 40 lakhs.
50 lakhs. Yes. 50 lakhs.
No, 50% of the, where's the decree? Let's see. So 50%, how much is the 50%? What is the money you're supposed to deposit? This is an appeal against the judgment and order dated, let's see. Where's the copy of the judgment and order?
In page number 47, Your Lordship.
47.
Yes, Your Lordship.
Oh, it's not written, you all are very obedient. But since that's a section 47, page 40,
Page 47.
47.
Yes, Your Lordship.
Amount is not reflected here.
In the last page, page number 50.
There's no whisper of the arbitration clause and submission, and the submission made in the court, the principal order.
In the last page, page number 53 of the judgment, it is the order that the suit is plaintiff is declared on a revision with cost as paid for. The defendant are liable to pay the principal amount 30,000 with interest at rate of 12% per annum from the year 2020 till the full and final realization. Cost of a sum of rupees 1 lakh. So the interest calculated from the January 2020 to, so about 42 lakhs.
So what is the amount you're supposed to deposit? Simply saying 50%, how much will you be depositing? Here.
In 24 years. About 40.
You have prayed for further time, saying you cannot deposit the amount yet. So how much are you supposed to deposit? Do you know?
Your Lordship, about 37 lakhs 20,000 plus compensation 1 lakh. So that the 38 38 lakhs 20,000, 50%, 98 lakhs 10,000, ma'am.
Do you agree?
19 lakhs 10,000.
Let's see how much is the 50. She's the one who's paying for time to deposit. So let's see how much is she supposed to deposit. Do you agree to the amount?
They're subject to the calculation.
Okay.
Principal amount was 30.
That's what
30 lakhs.
principal amount is
With
30 lakhs.
12% annum.
So the verbal order is for you to deposit 50% of the principal amount or with interest? What was the order previously? It's not written.
Principal amount.
Entire amount.
Yeah.
If it's the
Up
principal
till
amount.
now, whatever in amount,
You're not supposed to calculate the interest then. If this court had directed 50% of the principal amount, then it will be only 15 lakhs.
yes, ma'am, or your
I
lordship.
think you should be clear, isn't
Yes,
it?
yes, your lordship.
What was his last order? Of the principal amount. Okay, 50% of the principal amount of the degree, judgment and degree in the money suit number 12 of 2023.
23 years.
Okay. In view of the above, further time is given to the appellant to deposit 50% of the principal amount of rupees
15
30
lakhs.
lakhs. 30 lakhs. Principal amount of rupees
Yes, yes,
30 lakhs
30.
into the court. List the matter after 3 weeks, 2 weeks.
Well,
Weeks on a date fixed by the registrar.
just one thing I would like to submit,
Yes.
that since the defendants residing in the state of Rajasthan, Udaipur, and since first day of the proceeding, they admitted that after 2 months, they will deposit the amount.
But where? Nothing is
it-
reflected in
It
the
is,
order.
it is reflected in the first order passed by the learned trial court, your lordship.
Learned trial court, we're thinking, considering the appeal.
Yes.
So this court has not reflected any amount, but since verbally both of you have agreed, we have reflected. Okay, yes.
Right.
List after 2 weeks on a date fixed by the registry.
Right.
Hello.
Yes.
May I please, Lordship? Lordship, I am appearing for the respondent to Lordship, both the parties under process the settlements. Lordship. Both the parties are under settlement.
Under
Settlement.
settlement, you have settled the matter. You have petitioner?
Outside the
yes.
court.
Settlement is going on.
Okay.
So we
Not
need some
final
more
yet.
time. Yeah.
Miss so-and-so, learned counsel for the petitioner is present along with Mr.
Jeeta, Lordship.
Jiten, learned counsel for respondent number
2.
2, and Mr. So-and-so, learned additional PP for the state respondents.
May I humbly pray that
Lordship, the matter may be fixed on 23rd August.
The learned counsels for the petitioner, for the parties, submit that the parties are attempting to come to an amicable settlement outside court and has prayed for adjournment.
Yeah,
Yes.
matter may be on fixed for 23rd August.
As prayed for, list on 20th August 2020. Yes.
deeply.
May I please announce? Here, my lord, this case, the purpose of filing the urgent writ petition has been defeated during the pendency of the law. Therefore, the petitioner
To withdraw.
not want to press the case and withdraw with the liberty to file.
Okay.
If
Heard
so
Mr.
required.
So-and-so, learned counsel for the petitioner, who submits that the instant case may be allowed to be withdrawn with a permission to file a fresh, since the petition has become what, infructuous?
Not impressed, my lord. The purpose of filing the writ petition has
Since
been
the purpose
defeated, my
filing
lord, during pendency.
of the purpose for filing the instant writ petition has become what?
Defeated, my lord.
Depicted
Defeated, my lord.
or depicted,
Hmm.
okay, during the pendency of the instant writ petition. In view of the above, writ petition, the instant writ petition is disposed of on withdrawal with a permission to file afresh if so advised.
How will I?
Item number 13.
Yes,
May it please, your lordships. My lord, the paper seems to be very voluminous, but point involved is very short.
yes.
Now, my lord, my client is the chairman of People's Party of Arunachal. Now, there was an election of that People's Party of Arunachal on 14/10/2012. And my lord, the respondent as plaintiff filed a title suit, that is case number 10 of 2023, and obtained ex parte interim injunction on 22/12/2023, whereby election result of the chairman, which held on 22/12/2023, that was stayed. My lord, against that, we filed an application under Order 39, Rule 4, to vacating that order. My lord, we have stated all the facts which had been suppressed by the plaintiff in their plea. Now, we have elaborated everything, but the learned judge did not make any averment in the judgment. Now, ultimately, my lord, it was rejected. Against that, we filed an appeal. The appellate court gone further. My lord, as your lordship is aware, in a civil case, it is the duty of plaintiff to prove their case first. But in the appellate forum has seen, my lord, they did not try to get the position of that the plaintiff will prove their own case. That is, the plaintiff will have to stand on their own legs. Without going into all that, they have seen the weakness of the defendant, and on the basis of that, the appeal which was filed by us, that was also rejected.
Okay.
Now,
On the
my lord,
basis of the statement of the defense.
on the basis of the averment made in the plaint,
Okay,
and the
without
party-
being proved,
without any evidence.
okay.
And your lordship is aware that in any exceptional circumstances only ex parte injunction can be given. Now, I will take your lordships to the plaint first, which your lordship will find at page 74. Page 74. What is the averment they have made? This title suit 10 of 2023. The lordship will find the cause title as sued under section 5(9) of the Code of Civil Procedure, read with section 34, 38 of Specific Relief Act. For a decree, your lordship kindly see the line. For a decree declaring the title in favor of the plaintiff. Title in the sense they want to say, election was held on 14/10/2022. And that election should be declared as a valid election. They want to say that. My lord, the title is a misnomer here. Now, your lordship may see the averment made in the plaint, which your lordship will find at page, not from page 82, my lord.
Yes.
I'll read from para 1, my lord. The plaintiff's People's Party of Arunachal, for brevity hereinafter referred as PPA, is a regional political party of Arunachal Pradesh, and the party is registered with the Election Commission of India in August 1977 as required under Section 29A of the Representation of the People's Act 1951. Your Lordship may skip this para. Then your Lordship may see paragraph 2 at page 83. Now, the plaintiffs would like to bring into your kind notice that in the year 2019, the President and Secretary General of PPA was suspended from the party by the defendant number 2. Therefore, they filed a title suit before the Learned Civil Judge, Junior Division, UPL, for permanent injunction. After careful perusal of the record, the Learned Civil Judge, Junior Division decided the case ex parte in favor of them. The Learned Court issued a permanent injunction against the defendant number 2 from issuing arbitrary orders. This is in regard to earlier case, my lord. We are not much on it. Then para 3. The plaintiffs most respectfully submits that the state executive meeting, your Lordship kindly press the word state executive meeting, because
Yes.
if any amendment is required to be done, that will have to be done in terms of Article 29 of the People's Party of Arunachal. The Constitution speaks that. Now, in terms of that, my lord, executive member, my lord, cannot decide that. It will have to be done in terms of.
Show me in writing, where is that?
Yes, that article. Yes,
Article 21.
I'll take your Lordship to that. छोटा book क्या? हाँ, ये दे दो. Your Lordship may look the Constitution, that small book I am just handing over. Your Lordship may see Article 29 at page 20. Two zero.
Yes.
On the top, your Lordship will find Article 29 amendment. The party constitution shall be amended only by the People's Assembly. The notice or proposal for amending the constitution shall be given 1 month before the said assembly. Now, this averment has not been made in the plain. Now, what they say, on 14/10/2022, the election took place, and at the same time, the amendment was also conducted on the same date.
So Article 29.
Yes.
So this is done by the state executive.
Yes, they, in the plaint, they say in paragraph 3 that the plaintiffs must respectfully submit that the state executive meeting was held at the PPA office, Itanagar, dated 24/9/2022, where all the signatories like state executive members, district presidents, women wing executives, and state youth office bearers were present. And the House President has unanimously decided to adopt the following resolutions. Now they are saying about the resolutions. Article 13, PPA Central Working Committee shall be discussed in detail by the party executives. The House unanimously decided to do away with the post of CWC chairman, as it has been found redundant, regressive, and contradictory to the spirit of party policies and programs over various crucial issues of state importance, like so and so, so and so. Henceforth, the party shall be headed by the president. The House also decided to fix the basic qualification needed for the post of the party president. It was decided that anybody vying for the post of the party president should have been an active member of the party for a minimum of 3 years. Then your Lordship may skip this para. Your Lordship may kindly come to paragraph 4, my lord, at page 84. So the plaintiffs beg to submit that as the election was due as the term its previous executive members was over, hence one Sri Taba Tagar, a member of PPA, was appointed as returning officer for conducting election of PPA for the term 2022-2025. Accordingly, the returning officer issued a public notice through newspaper for nomination paper by notification dated so and so. Then paragraph 5, that the plaintiff humbly submits that the election was held on 14/10/2022, and the results were declared on the same date. Sri Kafa, and your lordship kindly say only 2%. Kafa Bangya elected unopposed as the president, and Sri Kaling Jarang was elected unopposed as the secretary general. These are the 2% only came unopposed. My lord, what we say, there was no election at all. It was just the namesake, my lord, they conducted there. And then paragraph C, kindly see, this is also important. The plaintiffs most respectfully beg to submit that on 4th November 2022, executive members has convened a People's Assembly. And as per the Article 29 of PPS Constitution, made 4th Amendment of the Constitution as per resolution passed on 24/9/2022, and removed, amended the post of chairman and laid down 3 years active member eligibility criteria for holding the post in executive. Now, this is the matter your lordship will see here. Now, what they say, they are saying that on 4th November 2022, executive members has convened a People's Assembly. Now, who can convene the People's Assembly? It is only by the chairman. And your lordship will find the election was held on 14/10/2022. And even the so-called amendment, there was no amendment at all. I will persuade the lordship to that effect. On 4th November 2000, they are saying that the amendment was on 4/11/2022. Now, if the election was held on 14/10/2022, on that date, the chairman was there in the power. Your election is required to be approved by the chairman. Now, the plaintiff is silent about
So
all this.
now this is all the work of the president, that's what you're saying.
Yes,
Is it?
president and secretary.
So
they
it
had-
should not be the president, should be the chairman. I think that's
they now say
Huh.
that the post of chairman has been amended
Huh.
by saying in the paragraph 6 what they are saying,
That it is
that
the
there was a
president.
resolution on 26, my lord, that you
That it will be the president and someone else, no? The president and
No, only chairman, the post of chairman will be amended. That will
by a president.
only the president will be
Ah.
termed as a chair. Now, before that, my lord, there should be an averment in the plaint, because the learned judge is going to, my lord, pass an order on the basis of the plaint, because you are passing an ex parte order. Now, at the time of passing an ex parte order, there is no evidence, nothing. Only plaint and the document which is annexed in the plaint. So therefore, you must not suppress anything in the plaint, because the learned judge will have to give his finding on the basis of the plaint only. Now, what is the averment? You never say that the amendment was conducted in terms of Article 29. My lord, once again I will read Article 29.
Yes.
The party constitution shall be amended only by the People's Assembly. The notice or proposal for amending the constitution shall be given 1 month before the said assembly. My lord, before the meeting, there'll have to be a notice that after 1 month that the meeting will be held, and the People's Assembly will decide who will be the president, who will be the secretary, all that. Now, what is the meaning of People's Assembly? Your lordship kindly see Article 11 at page 11. Page 11 है ना, थोड़ा देखना. Your lordship may come down to page 10, my lord. Article 10. Your lordship can you see Article 10 first?
Yes. Yes.
People's Assembly, the supreme organ of the party for the whole state shall be the People's Assembly. The conference of the People's Assembly shall be convened by the executive ordinarily once in every 3 years. Then your lordship come to 4. The People's Assembly shall be composed of delegates elected by the block, district and city executives, 10 from block and 15 each from the district and city. Now, your lordship kindly see whether there was any averment in the plaint that the People's Assembly conducted. There was a notice given for 30 days time that after 30 days the meeting will take place. All these things have been suppressed in the plaint. Then, my lord, even accepting their case as it is, my lord, if you say there is an amendment on 4/11/2022, Then election which took place on 14/10/2022.
Before the amendment.
Yeah, before the amendment, the chairman was there. Now, the president, the post of president will have to be approved by the chair. Now, whether there is approval, they're silent, they're totally silent in regard to all this factual position in the plaint. Now, your lordship may see Article 11(2).
With just one confusion, at this time, during this period.
Yes.
okay, During the time the election was held, was there an existing chairman?
Yes, yes. This
Okay.
chairman, my client was the
Okay,
chairman.
so
and
you
still
were bypassed. You are
bypassed.
that you were passed
Yes,
in the
yes.
plaint. Okay.
Now, this is the amendment in the plaint your lordship has seen. Then some other articles are there. I will take your lordship to that. Then what is the prayer your lordship can see at page 90. 90. Number 1 prayer for declaring the plaintiff's right over the title of People's Party of Arunachal. That means they want to say the election which took place on 14/10/2022 is a valid election. Now, in order to get this decree, there must be prima facie case established by the plaintiff. Whether that prima facie case has been established or not, your lordship may see the ex parte injunction order, which your lordship will find at page 166.
Yes.
Order dated 22/12/2023. Lordship may come from the case of the petitioner's plaintiff is that the plaintiff number 1 is the president of PPA and plaintiff number 2 is the secretary general as per election held and result declared dated 14/10/2022. The defendant number 2 was the chairman of Central Working Committee. However, on 24/9/2022, the executive members of the PPA convened a meeting and resolution was passed to remove the post of chairman by 4th amendment on 4/11/2022. Thereafter, the defendant number 2 ceased to be the chairman of the Central Working Committee. That by order dated 14/10/2022, the president of PPA submitted the updated list of office bearers to the Election Commission of India. However, the Election Commission of India by letter dated so and so informed that the details submitted are not in prescribed format of the commission. Therefore, on 27/9/2023, the plaintiff submitted the details as per prescribed format to the Election Commission of India. The defendant number 2 issued circular dated 4/11/2023 to convene a meeting by stating that the present office bearer's tenure has expired on 22/12/2021 as per the Election Commission notification dated so and so and published the same in local daily newspaper on 11/11/2023. On 11/11/2023, the plaintiffs issued a press notice informing party members to refrain from taking part in the meeting as it is unauthorized and illegal. The meeting was held anyway and defendant number 1, Sri Luiki Boje, was appointed as returning officer and conducted election on 12/11/2023. And the result was declared on the same day. The defendant number 2 was elected as chairman CWC. Defendant number 3 to 22 were elected as state executives. Now, counsel so and so for the petitioner plaintiffs submitted that as per Article 16 of the Constitution of PPA as amended on 4th November 2022 provides for PPA Central Working Committee. As per Article so and so, the president of the party shall be the chairman of this PPA CWC. Therefore, there is no separate post of chairman CWC. The defendant number 2 illegally issued circular dated so and so, and defendant number 1 illegally conducted election as declared result dated 12/11/2023. Therefore, the election result dated 12/11/2023 is illegal and liable to be quashed, and in the interim, the defendants be restrained from terming themselves as the People's Party of Arunachal Pradesh. It is prayed that temporary injunction may be granted ex parte ad interim as the object of granting the injunction would be defeated by the delay in service in the notice of application to the opposite parties. Peruse the plain miscellaneous application and the copies of the documents. Upon perusal of records and hearing, it is seen that the present case has been filed seeking for decree in favor of the plaintiff for declaration of title in their favor and a decree declaring the election result dated 12/11/2023 as illegal and permanent injunction under section 38 of the Specific Relief Act prohibiting the defendant from terming themselves as the People's Party of Arunachal Pradesh. I have gone through the letter dated so-and-so by the Under Secretary Election Commission of India to the President of PPA, wherein they stated that in regard with the updated list of office bearers furnished by your letter dated so-and-so, it is informed that the details submitted are not in prescribed format. Therefore, it is advised to furnish the organizational election details of the party, along with a complete list of office bearers, members of the committees, etc., elected as such election in the enclosed format. In the said letter, the Election Commission has not stated that the tenure of the present office bearers expired on so and so. I have also gone through the constitution of the PPA. As per Article 12(2), the president shall be elected for a period of 3 years, which implies that the tenure of plaintiff number 1 will be till 14/10/2025, as the election result was declared on 14/10/2022. The election result has not been challenged. Further, Article 14 of the Constitution of PPA is amended on 4th November 2022, provides for PPA Central Working Committee. As per Article 14(1) of the President of the party shall be the chairman of the PPA CWC, which implies that plaintiff number 1 is the chairman of CWC. Further, as per Article 36(1)(a) of the President, in consultation with the state executive, shall appoint a returning officer for conducting election of the party, which further implies that it is the plaintiff number 1 who is empowered to appoint the returning officer. In the instant case, the defendant number 1 returning officer was appointed by defendant number 2. The petitioners plaintiff have a good case to go into trial, and having their claims adjudicated upon, it is the party who would suffer greater loss would be paid to be having a balance of convenience in the favor. If the election result of the defendant dated so-and-so by defendant number 1 is allowed to remain in effect, the hardship or inconvenience caused to the petitioner plaintiffs will be much greater than which is likely to be caused to the OP. The state general elections are approaching and the political party is actively functioning. If the defendant number 2 to 22 are allowed to function as state executive of PPA, parallel to the plaintiff, the comparative mischief, hardship, or inconvenience which is likely to be caused to the petitioners by refusing the injunction is greater than which is likely to be caused to the opposite parties. The same is not granted. Therefore, the balance of convenience lies in favor of the petition. Further, an irreparable injury must be one of a kind which cannot be adequately compensated by damages. An injury will be regarded as irreparable where there exists no certain pecuniary standards for measuring the damage. In the instant case, if the election result dated 12/11/2023 is allowed to remain in force, then it will be difficult to bring back the party status to the present state. The damage caused to the petitioner's plaintiff would be such that it will not be possible to be compensated if the case runs out in the favor of the petitioner plaintiff. Further, the petitioner plaintiff has satisfied his court that the object of granting injunction would be defeated by delay in serving notice to the opposite party, considering the fact that if notice is to be issued, in the meantime, the opposite parties might end up making major party decision and alter the position of the party. Accordingly, the election result of the defendant number 2 to 22 dated so-and-so declared by defendant number 1, Sri Luiki Boje is hereby stayed until further orders. Further, the defendant number 2 to 22 are restrained from functioning the state executives PPA and further directed to refrain from using the emblem stamp so-and-so, so-and-so. Now, Your Lordship, kindly see whether the plaintiff's right has been established that the election which held on 14/10/2022 is a valid election. Whether it was the election, I mean, when the amendment of the post of the chairman was amended on 14/10/2022 is in terms of Article 29 of the Constitution of the PPA. Now, there is no, my lord, finding on the part of the learned judge. Now, it is the bounden duty of the plaintiff to establish their prima facie case that the election which held on that particular date is a valid election. Now, where is the finding? Your lordship will find nothing that there is irreparable loss, my lord. They have a good case to go on. These are the, my lord, routine manner everybody writes like that. But where is your finding? There is no finding at all. Then even, my lord, at that time I can understand, well, when you file a plea, if the plaintiff suppress certain thing, the learned judge may not know because he is passing an ex parte order. So therefore, when you get to know the thing, when we filed our counter application under Order 39 Rule 4 to making all detailed things, my lord, even then, my lord, they do not have any time to give any finding on those points. Now I will take your lordships to that. Please 57. Your lordship, can you see at page 57? Sir. 57. No?
57.
Yes, 57. That is the, in my lord, the application filed by us under Order 39(4). Now, after consideration of that application, learned judges passed this order. And there is, your lordship will find there is no application of mine at all. My lord, the appeals court time and again has said, when there is some amendment made by the defendant, you must meet it. You will have to give finding invariably. Because now you are in a position to know what has been suppressed.
Here the other side, huh?
Yes.
So.
Now,
what
your
is
lordship,
short?
I will start from paragraph 3 at page 57. The instant miscellaneous application has arisen out of so and so has been filed with the petitioner defendant under Order 39 Rule 4. Praying for setting aside ex parte order dated so and so passed by miscellaneous be so and so. The case of the petitioner defendant is that the petitioner number 1 is the founder president in the year 2007 of People's Party of Arunachal, who was elected as the chairman Central Working Committee of PPA on 23/1/2018 for session so and so. The opposite party number 1 and 2 were elected as president and secretary general respectively. After expiry of 3 years, no election were held. Hence, the members have continued to hold their elected post beyond the tenure of 3 years. The opposite parties have misled this court by placing reliance on non-existent Fourth Amendment of the Constitution of PPA. My lord, I will take your lordship to certain things. Why you are saying non-existence Fourth Amendment? Because there is a draft, my lord, Constitution I prepared by the 4 members. Out of 4 members, 3 of them say these were not done in terms of the party's constitution. So therefore, there is no amendment at all. Well, the papers which are there, I will take your lordship to letter. Now, I'll just read out this portion. The opposite parties have misled this court by placing reliance on non-existent Fourth Amendment of the Constitution of PPA and stated that as per the amendment, the post of chairman CWC, which was held by the petitioner number 1, has been removed. And its senior counsel, Mr. So-and-so, submit that as per Article 29 of the Constitution of PPA can be amended only by the People's Assembly. The notice or proposal for amending the Constitution shall be given 1 month before the said Assembly. However, there was no conference of the People's Assembly convened for the supposed Fourth Amendment. The drafting committee includes the opposite party number 2, Sri Kaling Derang, and 3 other members, Sri Rigam Santana, Sri Marli Kamki, and Sri Tai Tadap, who have raised objection with regard to the Fourth Amendment in their letter to the petitioner number 1. That the petitioner number 1 steal the chairman of CWC, the Fourth Amendment of the Constitution is untenable in the eyes of law. That as per Article 13, PPA Central Working Committee is the highest decision-making body of the PPA. Under Article 13(4), the PPA CWC shall be the highest executive authority of the party and shall have the power to carry out the policies and programs laid down by the party and the People's Assembly. That the opposite parties in their plain contends that an election was held on 14/10/2022, wherein the opposite party number 1 and 2 were elected as President and Secretary General. A notice with regard to election was published in the newspaper. However, the said election dated 14/10/2022 was never held. The opposite parties were appointed to their post by themselves merely for sake of formality, so that a list of office bearers can be sent to the Election Commission of India. The opposite party plaintiff prepared false and fabricated paperwork. That the petitioner number 1 wrote a letter dated so-and-so to the opposite party number 1, appealing him to conduct the election according to the provisions of the PPA Constitution by conducting People's Assembly and by giving 1 month prior notice before such election. The list of office bearers were sent to the Election Commission of India by the opposite party plaintiff. However, the Election Commission of India, by letter dated 18/9/2023, informed that the details submitted are not in prescribed format for the commission. The documents submitted by the opposite parties were not in the prescribed format, as documents were manufactured without conducting proper election. That after received the letter dated so-and-so, all members of PPA had written letter dated 24/9/2023 to the petition number 1, as is the chairman, CWC, to conduct immediate election for state executive members. The petitioner number 1, in compelling circumstances, issued letter dated 25/10/2023 to the opposite party number 1 to conduct fresh election, as the opposite party number 1 was elected by the People's Assembly as provided under Article 11(2). That in order to restore the party discipline in the capacity of the chairman of CWC, the petition number 1 notified circular dated 4/11/23, calling People's Assembly to be held on so-and-so. People's Assembly meeting was conducted on 12/11/2023, attended by 301 members, inclusive of executive members, and declared 4th Amendment of the Constitution as a nullity, and also elected new executive members for the session 2023-2026 under the returning officer Sri Louis K. Boje and assistant returning officer Sri Takam Taluk. So the unanimous decision of People's Assembly is the highest authority, and the decision of PPA made on so-and-so is to be upheld. The opposite party have not approached this court with clean hands. They have misled this court by relying on fabricated documents. Therefore, the ex parte temporary injunction granted in their favor by the order dated so-and-so is liable to be set aside. Then your lordship may skip these paras. Your lordship may come to page 61, para 19.
Yes.
Order 39, Rule CPC deals as follows. Order for injunction may be discharged, varied, or set aside. Any order for an injunction may be discharged or varied or set aside by the court on application made thereto by any party dissatisfied with such order, provided that if in an application for temporary injunction or in any affidavit supporting such application, a party has knowingly made a false or misleading statement in relation to a material particular, and the injunction was granted without giving notice to the opposite party, the court shall vacate the injunction unless, for reasons to be recorded, it considers that it is not necessary so to do in the interest of justice. Now, your lordship will find that the Article 29 was never complied because it is a mandatory provision, because you'll have to give notice of 30 days. All this thing they skipped.
Okay,
Then,
so what is the conclusion of the order of the court?
Beg your pardon?
So what was the order of the court?
Yes. Order, your lordship, kindly see at page 62, para 22. Therefore, in my view, the opposite party plaintiff may not have, your lordship kindly see, may not have followed the procedure provided under the Constitution for amendment of the Constitution. However, the contention of the petitioner cannot constitute evidence that the plaintiff have made false statement.
Okay, so
now, my lord,
the court refused to vacate its previous order.
Yes.
Is it? Okay.
Well, what she is saying, She's saying that the plaintiff may not have followed the procedure. Procedure is what? Article 29 is a mandatory provision. You'll have to give 1 month notice and there must be a people's assembly. Now, if these things are flouted, how the learned judge can say they may not have, my lord, followed the procedure, nonetheless, the election cannot be said to be invalid because there is no false statement. My lord, false statement in the sense, my lord, you have suppressed the vital element which ought to have been there in the plaint. You ought to have said, we have complied with Article 29, notice was served. Accordingly, People's Assembly was conducted and the election was held accordingly. And after the elections, my lord, the president who was elected, it was approved by the chairman. Where is that ever in the plaint? And how the learned judge was satisfied that all these things were complied? She herself saying the plaintiff may not have followed. Once she has said that is enough, that means you have satisfied that those mandatory conditions were not complied with. So therefore, my lord, how casual they can be, my lord, your lordship, kindly visualize the situation. And my lord, the law is so clear. My lord, the appeals court time and again say, when you are to do certain thing in a certain manner, you'll have to do in that manner only. You can't choose any other manner because Article 29 mandates that you'll have to call up a meeting and before that you will have to give a notice for 30 days. After the completion of 30 days, you will have to go for the meeting. That these are all, my lord, not complied at all.
Okay, just read the whole of para 22 because the reasoning has been made by the learned trial code.
Yes.
Isn't it? So just read the whole para.
Yeah, reason, my lord, yes. I'll be reading once again. Therefore, in my view, the opposite party plaintiff may not have followed the procedure provided under the Constitution of Amendment of the Constitution. However, the contention of the petitioner cannot constitute evidence that the plaintiff had made false statement. This court is of the opinion there is no knowingly false or misleading statement made by the plaintiff in the plain or in the interim application for temporary injunction, and at best, an incorrect, inadvertent statement has been made by the deponent in the plaint and temporary injunction. My lord, I will say is a very, very casual approach because what they have suppressed, because if they were really correct, my lord, there ought to have been environment in the plain that the People's Assembly were conducted by following the Article 29, notice of 30 days were given. Now, all these things have been, my lord, very conveniently, my lord, skipped. And by doing that, you have said that the amendment was done. The chairman will not function anymore. The approval of the chairman is not required. Now, where is the finding in regard to all that? Once you fail to give such a finding of a mandatory provision, and then you can say that, well, they intentionally did not make all false statement. So can it be a reason? A senior judge, my lord, giving such reason, which has got no legs to stand.
Yes, go ahead.
Now then, para 23. Having considered Order 39 Rule 4, in my view, the petitioner's defendant has in the present case failed to establish discharge the burden of proving that the plaintiff has knowingly made a false or misleading statement in relating to material particular. Now, what is the material particular? Material particular is that you are saying that the amendment of the Constitution was done on 14/10/2022 by complying all the provisions of the Constitution. That is material particular. And is there any indication in the plaint that that Article 29 complied in toto? There was a notice given. So these are the things, my lord, cannot be skipped in that manner. And then, my lord, against that we filed an appeal. And how the appellate authority has decided, my lord, that is also one peculiar judgment. 44.
Appeal before the district judge?
Yes, my civil judge senior division. My lord.
Senior, okay.
Madam.
This is junior division.
44. Your lordship will find that at page 44. No? Now, what he has done, he has considered the case of the defendant. He has not considered whether the plaintiff could establish his prima facie case. My lord, judgment starts at page 44. I like to read it from, my lord, paragraph 2, no? Paragraph 2 itself, my lord, at page 44. The case of the appellant is that the instant appeal has been preferred to set aside the lordship has skipped this part. My lord, from page 46. 46, paragraph 5. It is averred therein that grounds for instant appeal are that the learned court below erred in law as well as on facts in passing the impugn order dated 4/3/2024 and order dated so and so, title suit number so and so, same are liable to be set aside. That for grant of temporary injunction, there has to be prima facie case in favor of the parties seeking injunction, and there should also be balance of convenience and irreparable loss in their favor. Whereas there was no prima facie case since respondent number 1 and 2 were elected as president and secretary on 14/10/2022 without complying Article 36D of the Constitution of PPA. That respondent number 1 and 2 misled the lower court below by stating that there was Fourth Amendment to Constitution of PPA and post of chairman CWC was removed, and that executive members had authority to amend the Constitution, whereas executive members had nothing to do with the amendment. That Article 29 of the Constitution of PPA provides that Constitution can be amended only by People's Assembly, and 1 month notice is required to be given, but requirement of said provision were not complied. That there was no pleading to the effect that election and Fourth Amendment of Constitution of PPA was done by People's Assembly. On the other hand, no written reply was filed with the respondent. Then point for determination. The lordship may start from paragraph 8. The learned senior counsel for the appellant so and so submitted that after the election of PPA held on 23/12/2018, the appellant was elected as chairman. Respondent number 1 was elected as president, and appellant number 2 was elected as secretary of CWC of PPA, and the terms got expired on 22/12/2021. The election dated 14/10/2022, by virtue of which respondent number 1 and 2 are claiming to be president and secretary of CWC of PPA party, was not conducted as per Constitution of PPA. Article 11(2) of PPA Constitution states that president shall be elected by People's Assembly for a period of 3 years, and Article 13(6) states that CWC shall be responsible for convening the People's Assembly. In the instant case, appellant being chairman, CWC did not convene any People's Assembly for the said election dated 14/10/2022, and therefore said election dated 14/10/2022 is not legitimate and cannot be basis for granting injunction order in their favor. There is the Fourth Amendment of the Constitution of PPA, by which respondent number 1 and 2 illegally removed the post of chairman of CWC by passing resolution dated 24/9/2023, was not as per the due procedure, since Article 29 of the Constitution of PPA requires that party constitution is to be amended by a People's Assembly, and before that notice of 1 month is to be given. However, in instant case, no People's Assembly was held prior to Fourth Amendment on 24/9/2023, and neither 1 month notice was given. He highlighted that in the copy of the said resolution annexed by respondent number 1 and 2, with their plaint and application before the lower court below, although name of respondent number 1 is there, but his signature is missing in the document, which raises doubt on the authenticity. Party submitted that after issuing a notification, appellant held election on 12/11/2023, by which appellant was re-elected chairman of CWC PPA along with pro forma defendants as its other members, and this election was stayed by the learned court below. On the other hand, learned counsel for the respondent number 1 and 2 so and so submitted that respondent number 1 and 2 did not mislead the lower court below, and both impugn orders of the lower court below are just and proper and needs no interference. He submitted that the result of election dated so and so was rightly stated by the lower court below, since Article 38(1) of the Constitution of PPA states that President in consultation with the state executive is to appoint a returning officer for conduction of election of the party. However, in the said election conducted on 12/11/2023, President, who is the respondent number 1, had not appointed any returning officer, and therefore the election dated so and so, by virtue of which appellant is claimed to be the chairman, is invalid. Further is submitted that said election dated 12/11/2023 was conducted by appellants by misguiding the party workers, that Election Commission of India by its letter dated 18/11/2023 directed to conduct election. However, in the letter of Election Commission of India addressed to PPA dated 18/11/2023, there was no direction to conduct an election. He highlighted that appellant had not challenged either in the amendment or the election dated 14/10/2022 before the lower court below in their written statement, nor file any counterclaim with their written statement in connection. I have heard, now your lordship, see paragraph 11. This court is exercising the power of appellate court, which is very limited in nature.
No, what is this thing, the Election Commission of India? What was the, just come back to that.
Your lordship,
Concerning the opinion of the Election Commission of India, they had directed to conduct election, isn't it?
that means, my lord, in 2021, the term was over. Then it came to the focus of the Election Commission. The Election Commission has said, since it has been expired, you are to carry on election. So therefore, that election process was started by the chairman. Because the election which was conducted by the plaintiff, there was no election at all. It was just a showcase, my lord, that on 14/10/2022, there was an election and there was an amendment. My lord, had it been correct, there would have been amendment in the plea that the amendment was conducted in terms of Article 29. Now, both the judges, your lordship has seen, the Civil Judge Junior Division as well as Civil Judge Senior Division, they are not, my lord, scrutinizing the prima facie case of the plaintiff, whether the election held on 14/10/2022 is there really an election and is a valid election. And the prima facie case of the plaintiff was never inquired into by both the judges. That is, my lord, that is his first prayer, that my title in regard to the election held on such and such to be decreed. 14/10/2022, that's the first election which was conducted by the plaintiff. Now, in order to establish that, it is the bounden duty of the, my lord, both the judges to see that when you are asking for some relief, whether you could establish your case, whether that election conducted on that day, 14/10/2022, whether it is in terms of the constitution of the PPA, People's Party of Arunachal. Now, your lordship has seen, both the judges conveniently ignored that. In civil cases, plaintiff will have to stand on their own legs. You cannot stand on the, my lord, weakness of the defendant's
So,
case.
no, say, after the election which was held on 14/10/2022, there was another election.
Yes.
Held on 12/11/2023.
Yes, well, that is a subsequent
So this was
election.
the one which has been stayed.
That has been stayed, my lord. Subsequent election has been stayed. My lord, as if we have come before.
So what is the observation of the Election Commission on this?
My lord, Election Commission is ignorant about all these things, because what happened, my lord, when Election Commission came to know that their election term expired on 2021, then they have informed that the term is over, so you go for an election. So the peoples of the locality, all the members, they have wrote many letters to the chairman to go for a election. In view of that, he started election in 2023.
2023.
My lord. Now, they have come before your lordship saying that that election is invalid and the election which we have conducted,
2022.
yes,
Hmm.
that is valid. Now, if you say that is valid, where is the prima facie case by both the court? Now, therefore, my lord, in short compass, what I can tell you, lordships, that these matter is required to be remanded back to the trial court. Let them establish their case by adducing evidence.
Hmm.
My lord,
So-
that is the position of law. My lord.
Yes, so this is just the injunction order which was passed.
Yes.
Just saying that. So what is the main issue before the trial court in the main case title suit?
Main case,
Title
I,
suit is not disposed of yet. So
no,
title
no,
suit,
main case is not proceeding
it's now pending.
because the case is
Because-
pending here.
Yes, yes.
Therefore, in the guise
So
of that,
main, this thing in the title suit is for recognizing the election which was held in 2022,
yes,
isn't it?
yes.
Oh, okay, by staying the, okay, fine.
No,
Yes, so what is the reasoning of the?
Yes, the
trial
reasoning is, my lord, fantastic. My lord, I will take your lordship to that. He has scrutinized.
Para 11 maybe?
My lord, in para 11, your lordship kindly see. He's saying the appeals court power is very limited. Then by relying on the appeals court decision, Honorable Appeals Court, I would like to reproduce the observation made by the Honorable Appeals Court in Wonder Limited versus so-and-so, 1990 supplementary SSC, wherein the Honorable Court has laid parameters for interfering with the order of trial court in injunction petition. In the said case, it was held, the appeals before the division bench were against the exercise of discretion by the single bench. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the settled principle of law. Now, in this case, my lord, this legal position is very correct. There cannot be a true opinion on that. But in our case, what happened? We have decided quite arbitrarily. We are not trying to decide whether the plaintiff could establish their prima facie case. Whether the election held on 14/10/2022 is a valid election. Both the judges have ignored. They did not give any finding. They did not like to go into that. Only thing, they have a good case. If the election, subsequent election is not stayed, they will suffer irreparable loss. Are this can be constitute to be a reason? Well, any ex parte order to be given by the learned judge is required to be given, the substantial reason must be given to that. There are so many decisions of the appeals court. I will take your lordship with those decisions also. Now, your lordship kindly see the finding given at, if your lordship look at paragraph 15. 15, page 51. Firstly, I am inclined to discuss the impugn order dated 4/3/2024, passed by learned civil judge, Junior Division, Capital Complex. The relevant portion of the impugn order dated so-and-so passed is reproduced, that your lordship has seen. In the present case, the defendant has sought for vacation of the order. Then the contention on behalf of the petitioner defendant is that plaintiffs had made false statement and misled this court that there has been Fourth Amendment to the Constitution of PPA and the post of chairman CWC was removed. Plaintiffs furnished copy of the resolution along with the signature of the state executives. The letter dated 24/10/2023 at Annexure 3 of the application also shows that the state executive did not deny that there was a resolution for amendment of the Constitution. Therefore, in my view, the opposite party plaintiff may not have followed the procedure provided under the Constitution. He has repeated that, my lord. I mean, he has quoted that. Then, my lord, your lordship may come to page 54, para 18. From the aforesaid highlighted portion of the impugn order, it is seen that the learned court below has duly considered all contentions, both the parties in the application under Order 39, Rule 1 CPC, in case number so-and-so, and has referred to relevant articles of the Constitution of PPA, and thereafter come to the decision that although Fourth Amendment to Constitution of PPA made by respondent number 1 and 2 and other members of PPA executive body has not complied with the provision of Article 29 of the Constitution of PP, which requires People's Assembly to be held and 1 month prior notice, but same cannot nullify. Now, Your Lordship, kindly just try to realize what sort of order it is. They are accepting that Article 29 has not been complied. 30 days notice has not been given. Nonetheless, what is it? Requires People's Assembly to be held 1 month notice, but the same cannot nullify the election held on so and so. Is this be construed to be a reason? Now, you are accepting that mandatory provision has not been complied. And then again, you are saying this cannot be construed to say it's nullifying the election dated so and so. Even, my lord, a person who is joined in the profession today, my lord, he will also not write like this, because you are contradicting yourself. You are saying there is an emphatic violation. It has not been complied. Then again, you are making a somersault. You are saying, oh, no. Even that also, it will not nullify the election dated so. Can it be a reason order? It is seen that the learned court below has further reason. On the other hand, election held on, then Your Lordship, kindly see. This is another, he has gone on reverse angle. My lord, in a case, when a plaintiff files a case, it is incumbent upon him to justify his case when he wants a decree. That on the basis of the complaint, this is my case, I want a decree that the election held on such and such a valid election. Now, the court is not going to that, rather saying that the election held by me on such and such date, that is also invalid.
Later election.
Yes, that injunction order cannot be granted on my witness. Now, exactly he has done that. My lord, it is seen that the learned court below has further reason on the other hand that the election held on 12/11/2023, by which appellant was re-elected to chairman, CWC shall be considered illegal for violating the provision of Article 38 of the PPA Constitution, as appellant had no power to appoint a returning officer to conduct any election, even if assuming appellant was the chairman, CWC of PPA. In my opinion, the aforesaid reason and decision made by the learned court below does not show anywhere that trial court used its power in an arbitrary, capricious, and perverse manner, since the said reasoning and decision is based on the provision of Article 38. My lord, what we want to mean by quoting Article 38? Article 38 stipulates, my lord, the returning officer is required to be appointed by the president. Now, here in this case, Your Lordship, kindly see the peculiarity of the case. The president is from the he started anti-party activities. So therefore, he held an election on 14/10/2022 for the two persons, president and secretary general. And in the, my lord, host of so many members, no other members were elected. Now, here they are saying, in terms of the Article 38, if the returning officer is to be appointed, that will have to be appointed by the president. Now, in this case, cannot, because the president is on the other side of the camp. Now, the People's Assembly selected Mr. So-and-so, it has to be a returning officer. Now, you are scrutinizing the case of the defendant. Now, here, first thing you will have to say, whether the plaintiff has succeeded in establishing a prima facie case, that is nil. Neither civil judge junior division has, my lord, found out the prima facie case of the plaintiff, nor the appellate forum. So, my lord, my submission would be, it is better to send back the matter to the trial court. Let them, if they can establish their case by evidence, it is fine. Your Lordship may give 3 months time. Within that time, the election will be held. I mean, they will finish their taking evidence and all that argument. My lord, the Appeals Court recently also held that 3 months time is enough for, my lord, the scrutiny of the matter.
Now, did you submit your written statement?
Yes, we have filed.
You have filed a written
Yes,
statement also? Okay.
The matter is ready, is not proceeding because of pendency, possibly pendency of this civil division petition here. Lord, I can take your lordships of various judgment, but if your lordship can, my lord, think of sending it back, then possibly I may not do some other.
Sending it back by vacating the order of stay.
Obviously,
Stay
madam,
of this
that
order.
will have to be set aside.
And then sending it back. And that's your prayer. Anyways, we'll see.
My lord, if your lordships want me to, my lord, satisfy your lordship through the decision,
No, give you authorities you want to rely on.
my lord, yes.
But not too many of them, just the, it's not the same points, okay?
My lord, I will first submit before your lordship certain decision on suppression of material fact in the plea. Really, है ना? एक साथ दे दो। एक साथ दे दो बेचारा बार आएगा ये। My lord, the first decision I will take your lordships to 2018 SCC online, Bombay 3043. Now the relevant paragraph, my lord, paragraph 22 to 25. I'll just read out, my lord. Paragraph 22 reads, it's tried that a plaintiff who approaches the court, particularly in order to seek any equitable interim or ad interim relief, which are essentially discretionary, must not suppress any material fact or particulars, but must make true and correct statements in the plaint or in the application seeking such interim relief. This is a case where clear misstatement of facts, and that too quite a material fact, has been made by respondent plaintiff in the plaint, on the basis of which respondent plaintiff have applied for interim reliefs. My lord, material facts in the sense, my lord, when they have, my lord, submitted the plaint before the court. Ordinarily, my lord.
They mentioned the article.
Yes.
But they did not explain the contents of Article 29, is it?
Article, my lord.
Because they mentioned Article 29.
Your lordship may note the different articles.
What is the content of Article 29?
Yes.
It was not followed. That they did not mention. I think that's your point.
29, then
The
my lord,
procedure not followed.
other articles are also there. Your lordship may kindly note. Article 29, then Article 11, subclause 2. Article 14. Then Article 33(6)(d).
What is Article 33(6)(d)?
Then Article 13. Oh, 36(d). 36(d), your lordship may see for FY. Please 22. 36(d) is, my lord, functions of People's Assembly. D speaks to elect the state executive by secret ballot. Now, whatever, my lord, the chairman is the apex body of the institution. Any sort of resolution, any sort of appointment that will have to be approved by the chairman. So on that particular date, when the election was conducted on 14/10/2022, his appointment was never approved. So therefore, all the articles are very important, my lord. And these were the things which has been material fact and relevant fact, which are suppressed in the, my lord, plaint. Then para 23, unfortunately, though this issue was squarely raised, this issue means, my lord, the aberrament which they did not make in the plan. By filing our petition under Article 39, 39 subclause 4, my lord, we have contended all these things, and those issues were also ignored by the learned judges. Unfortunately, though this issue was squarely raised by appellants, defendants in their written statement, reply to application for interim relief has also written submission filed before the learned trial judge. The same has not been adverted to by the learned trial judge in the impugn order. Exactly in this case, my lord, she did not like to advert anything. It is not the case of the respondent that such a issue was not argued before the learned trial judge. so as to excuse non-consideration of such relevant and vital issues. There is therefore a case of total non-consideration of very relevant and vital issue, which imports the exercise of discretion in a manner in this nature. Then, my lord, the learned judge referred Wonder Limited. The lordship has also said here in para 24. In Wonder Limited, the Honorable Supreme Court has held that in appeals against essentially discretionary orders, the appellate court will not interfere with the exercise of discretion of the court of the first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the settled principles of law regulating grant of or refusal of interlocutory injunctions. In this case, one of the settled principles of matters of grant or refusal of interlocutory injunction is whether the plaintiff or the appellant who seeks such interlocutory injunction has approached the court by
Okay, so this, I've got your point, suspicion of
material
facts.
Right.
Yes,
This is in regard to that.
suppression of material facts in this, then what?
And then 2005 SCC Online Bombay. That is, my lord, there are different paragraphs. My lord, what is fraud? All these things have been explained. In para 8, your lordship kindly see.
So you're saying that they have committed fraud in the instant case or what?
My lord, your lordship may look at para 8.
Para 8, what does it say?
The learned counsel for the respondent submitted that this petition deserves to be dismissed with exemplary cost because the
Suppression of material facts, same, so leave it. You have
more or
cited
less-
one the same case, no need of citing too many authorities.
more or less, my lord,
I think the first cases will suffice in your case. The first
My lord,
authority.
your lordship kindly see the paragraph
Otherwise,
60.
usually more or less the same. 60.
Paragraph 60, your lordship will see that both the courts did not, my lord, recorded the findings in terms of what we have stated in our petition. Therefore, my lord, the paragraph 60, it has been said, the court will not be the abater to iniquity. That means, my lord, the court is no individual interest is there. So therefore, it is expected they will pass the order reasonably by giving all findings. In that context, my lord, the lordship has said, the court will not be the abater to iniquity. Thus, one who seeks the aid of equity must come into court with clean hands. My lord, in this sort of cases, they are asking for a relief of equitable in nature. So if you want to equitable relief, you must come in clean hands. You must state what is the fact of the case.
Yes,
You should not,
what's your point?
my lord, then
Anything else?
para 99 SSC online.
Yeah, what is that about?
That is para 8, my lord, a small paragraph.
Again, if it's concerning no clean hands,
This is equitable
suppression
relief.
of material facts, and leave it, it's okay.
Equitable relief.
Ah.
I'm not, my lord. ये क्या है? 2004 7 SCC 166.
It's
Para
okay.
13.
How many authorities are you going to rely on?
Yes,
Too
my
many
lord,
is not required. Give it.
these are more or less.
Material facts. This is concerning the material facts, not
Right,
brought
right.
up before the court.
My lord, I will not
Say,
multiply, my lord, if it is
material
not
facts.
required.
So leave it. I think
That
that is your main point, isn't it?
Yes, yes.
With
My lord,
these-
there are some other points on whether the plaintiff must succeed in his case. To that extent, my lord, just two decision. My lord, the apex court is
See,
stay.
your one point was that the plaint, their case has to be established first, isn't it? Which was not established in the instant
Yes,
case.
yes.
So
The-
if you have anything on that, you give me one judgment.
The next point, my lord, the plaintiff must succeed or fail on his own case. And he
Okay,
cannot
so
take
own
advantage
case.
or weakness of the defendants. So that, your lordship may
That one
require.
point we can consider.
That is 1998 4 SCC 539.
Is it here?
I have given it,
90,
I think
94,
98 4 SCC 539.
1998.
Yes.
SCC 539.
Page, I mean, the paragraph will be paragraph 10, my lord. Paragraph, yes.
Yes, the plane should stand on its own legs.
Paragraph 9, my lord, last line, your lordship will find.
But this thing is not here with me.
Yeah.
1998, 4 SCC 539.
539.
Correct, huh?
Done it. Some mixed कर दिया क्या?
Para 910. Leave it, anything else?
और ये then Sunil Kumar. Another decision.
See, because
This also I'm relying on
what
para
is
10.
almost over. Para 10 is
Paragraph
what?
10.
Again, same.
Admittedly, plaintiff
must-
is not
Plate
entitled
must
to.
stand on its own legs?
Yes, yes.
Same. Then leave it. One is enough.
My lord, some other points there.
On the weakness of the defendant's
Yes,
case.
yes.
Huh. But your submission is that your case was not considered, isn't it?
Yes, yes.
Hmm.
If your lordship decide on that, it's good.
Yes.
No,
Ah,
please, lordship.
You are for respondent number?
Yes, my lord, for respondent number here in this revision, my lord. Yes, I'm for 1 and 2.
Okay. Respondent number 1 and 2 are the other people, what, president?
President,
The
secretary.
private.
Yes.
Okay, president and secretary, yes.
Lordship, first of all, in this, we have preliminary objection that we have raised before this honorable court is in our affidavit. First of all, is that the petitioner here has indeed suppressed the material fact before this honorable court during the filing of the civil revision petition itself. Lordship may kindly take up the.
Accusing each other of suppressing the material
Yes,
facts.
yes, material fact.
Ah.
Can take up, Lordship, affidavit, Lordship.
Yes.
Respondent 1 and 2, Lordship.
Both of you are saying that you're suppressing the
No, madam,
facts.
that I'll come to that one. First of all,
So
in
who is
regarding
really
this
suppressing?
particular civil revision petition, madam.
Okay. Where is your counter affidavit?
Yes, madam, by respondent 1 and 2, Lordship.
Let me see.
Lordship got it.
Not yet.
Now, Lordship, before filing of this civil revision petition, the petitioner has approached the learned civil judge junior division by filing a title suit, my lord, for declaring our election as illegal, which is being challenged here also.
Isn't this concerning the
Yes, definitely is
of the later election?
connected. Yes, but
2023?
lordship, connected with this. If lordship sees the prayer, lordship, in the I have annexed the petition also, lordship.
Where?
In our affidavit, lordship.
Wait, let's see. Let's come to your affidavit.
Lordship will find the prayer in page 33, lordship. Internal 21.
Let me come to your affidavit first.
Lordship got it.
No, not yet. Where's your counsel?
Affidavit, my lord,
Filed on when?
lordship will file on, I'll just, on.
See, where's the counter affidavit filed?
Two, 1 and 2.
Okay, it's in the other file.
April, my lord. Yes, lordship.
This file, not in the main one.
Yes, lordship.
If lordship comes to the prior portion of their application, page 33, lordship.
Page 33 of your counter affidavit.
Yes, lordship, yes. Which they have not annexed in the civil revision petition. Lordship,
Page 33 of your counter affidavit.
yes, lordship.
Mm.
Your lordship has got it in internal page 21, according to the.
Yes.
Yes, lordship. Kindly see the first prayer, madam.
Mm.
For declaration of the purported fourth constitution amendment of PPA approval dated 14/2/2023 and publication date 10/3/2000 is as null ab initio, illegal, nothing binding and enforceable against the plaintiff. Lordship, which has been time and again mentioned that it has not followed the constitution article 29, Malo. That. And for declaration of the purported PPA organization election 14/10, Malo. Same Malo which is there in this revision petition. They have not annexed this one. And they have not even mentioned Malo that this petition is pending before the lower court. Therefore, lordship is aware, my lord, if someone approaches this honorable court in a special revision, my lord, suppressing the material fact, my lord, the case cannot be heard on merit, my lord. It should be dismissed there and, well, in the first instance itself.
No.
All this were not brought before the civil revision petition, madam.
See, so what you're reading
Yes.
is a petition or a plaint which is filed in civil suit number 2.
Yes, which is, they have filed, my lord.
You
Earlier,
have filed one,
yes.
and then you have also
After that,
filed.
they have filed, my lord, which is pending before the learned civil judge, my lord.
What about this thing? You have also filed.
Yes,
this
but
thing.
that they have challenged the order. Against that order, they have come
That
in
is
this
registered
revision.
as civil suit number, a title suit number.
That is the different, my lord.
Your case. Title suit number
Ours is 10, my lord.
10.
Yes.
Okay, yours is title suit number 10 of
2023, lord.
23. So while this title suit was pending because of the injunction petition, whatever, injunction order, in the meantime,
They have filed
a
this
title
title
suit number 2 was also
of
filed.
2 of 2024. Lord.
But how can you file title suit number 2 of 2024 when the matter is?
What they have filed, madam.
Judice?
They have filed. Not us, madam. They have filed.
Okay.
They have filed, my lord. After filing, they have approached this honorable court for filing this civil revision petition, madam. That's why.
Okay, for vacating the
Yes,
injunction
madam.
order.
Yes. Whereas the prayer is same in the civil suit, madam. For vacation of our election and all that, madam. They have not mentioned, madam, that this petition is pending, suit is pending before the learned civil judge in this civil revision petition. Not a single, nowhere it has been, madam, mentioned.
But
Kindly
now
see-
there are 2 title suits pending.
That's why,
They
madam.
matter.
Yes, that ought to have been, madam, disclosed by the petitioner before this honorable court, madam.
Okay.
That they have not disclosed in the civil revision petition, madam.
So pending of title suit number 10, 2023.
No.
Title suit number 2, 2024 is filed. That's, I
Yes.
think that's your case.
2 of 2024 was
24.
pending, but while filing this civil revision petition, the petitioner has not disclosed that fact before this honorable court, madam.
Okay, fine.
That's my first contention, madam. If this honorable court sees that the petitioners have suppressed that fact, my lord, this revision must be dismissed, my lord, right now, madam, without going into the merit of the case. Lordship, your lordship is aware of the judgment, my lord, this honorable court and Supreme Court, my lord, time and again has said, my lord, when there's a suppression of fact, my lord, and material facts have not been brought before this honorable court, while filing a petition under 226, 227, my lord, needs to be, my lord, dismissed, my lord, merit need not be gone into, my lord, in that case.
So is this a suppression of facts that
Yes, my
no
lord.
civil suit was filed, huh?
If they have
Okay.
cursory mentioned, my lord, that would have been sufficient, my lord, that such and such case is pending, my lord. That also has not been done in this case.
Okay. Oh.
Lordship, that's why I'll just, our own High Court, my lord, regarding suppression of fact, my lord. I'll just, my lord, two judgments, my lord, Supreme Court and Lordship, just I'll mention the paragraph. I'll not, my lord, read the detailed paragraph 9, my lord, in the GLT case, my lord. Paragraph 9. It starts with 7, my lordship. So it starts with 7, 9, and 10. my lord.
Yes.
Merit need not be gone into after that, my lord. And 2024 months, my lord, this equivalent to 2024 1 Supreme, my lord, is paragraph 43 onwards. Supreme Court, lordship, got it. It starts with also para 43.3, lordship, it starts with. It's a voluminous judgment, my lord. Lordship. My lord, if kindly, it starts from page 61 of the judgment, my lord. Actually, para 43. Lordship got it, Judge.
Yes.
I'll read para after that one. Suppression of lordship got it. Suppression or concealment of material facts is not an advocacy. It's a jugglery, manipulation, maneuvering of misrepresentation, which has no place in equitable prerogative jurisdiction. If the applicant does not disclose all material facts fairly and truly, but states them in a distorted manner and mislead the court has inherent power in order to protect itself and prevent an abuse of its process to discharge the rule nisi and refuse to proceed further with the examination of the case on merits. This is the judgment of the Supreme. Merits need not be gone into. Lordship got in page 61.
Yes.
I'm not after, at least some cursory mention ought to have been there in the civil revision petition. Not even a cursory mention also. Otherwise, it has a correlation with the same election, which was under challenge in our suit. Now, Lordship will kindly appreciate. They have filed an interlocutory application. Kindly see their application. File an interlocutory application for staying the election.
Where is that?
Lordship, affidavit, kindly see the in that same, Lordship. They have filed an IA also.
Where's the IA?
Well, in the same, in a counter affidavit, Lordship will see the prayer in page 126 of the counter affidavit, last. That amendment, Lordship, which they say it has been illegal, my lord. They are saying that amendment which we carried out was illegal. Lordship got it on page 126. First prayer, suspend, stay operation of purported for constitutional amendment of PPA approval dated 14/2/23 and publication date 10/3/2000 till pendency of title suit. Now, second, suspend the state of operation of purported PPA organization election 14/10/2022 till the pendency of the title suit. Now, Lordship will kindly appreciate if the petitioner succeeds in this civil revision petition, my lord, that prayer, my lord, the interim order will automatically go, my lord. Otherwise, my lord, if they succeed in that prayer of the interim order, my lord, then this revision petition goes, my lord. Because they won't have any more grievance, my lord, if the law, the court below stays our election, my lord. Now, both the sides, my lord, they are trying both sides to, my lord, if they succeed here, my lord, if they don't succeed there, this will apply, my lord. If they don't succeed, that interim prayer, they still have to continue with that prayer, my lord. They will press for that one interim order, my lord. It has correlation anyhow. This ought to have been disclosed, my lord. That's what I'm saying, my lord. This has not been disclosed in the revision petition, my lord. Not a single line.
State the operation of 10/20/22.
Yes. Which they are saying, my lord, with the amendment which we carried out, they're saying, my lord, that should be stayed. And the election which we conducted 14/10/2022, that also should be stayed, Lord. If those are stayed, my lord, they will have no more grievance in the civil revision petition, man. One more grievance they will have, my lordship. They will not press for that vacation of the interim order also. If they get this stay, man.
Okay, got it point.
My lord, there might be married, demarried. My lord, I'm not going into that, my lord. At least these things ought to have been brought before this honorable court, my lord, while filing the civil revision petition. Because these things were already pending before the learned civil judge junior division. It is not a case, it was not pending. So if your lordship, my lord, takes a call on this one, saying that they have suppressed the material fact and merits need not been gone into, my lord, I'll rest my case, my lord. But if lordship feels that I should argue on the merit of the case, then also, well, I will argue on the merit of the case also.
So
Otherwise,
let him have a say on this fact that you have suppressed the fact that another title suit is pending.
My lord, your lordship kindly see what is the prayer in our civil revision petition at page 36. My lord, this is an unnecessary issue. My lord, we are trying to bother your lordships. It's a non-issue, my lord, I will say. There's no question of separation. Lord, who has been affected by that?
Page
36.
36 of your?
Of the revision petition, my lord. Lordship, see the prayer.
This is it.
Now, judgment and order dated 21/3/2024, passed by the learned civil judge, senior division UPR district, in title appeal number so and so. Then order dated 4/3/2024, passed by civil judge, junior division UPR, in the title suit number so and so. These are the judgment to be, my lord, set aside. Now, my lord, we have filed a suit. Now, how is somebody is going to be prejudiced by that? Now, if your lordship finds that this order should go back to the trial court, both these suit will be heard together. Who is going to be affected, my lord? And now, supposing we haven't mentioned it, how they are going to be affected by that? We have come.
When you say suppression of facts, we
My
have
lord,
to
that
look at the
suppression-
judgment which has been cited. What is the nature of the suppression of
Yes, your
facts
lordship
there?
will-
And the nature of the suppression of facts in this case?
Yes, definitely, my lord, it had a correlation. At least, my lord, that ought to have been brought before this honorable court. That's what I'm submitting, my lord. At least I mentioned that such and such suit is pending. Definitely, I'm not saying, my lord, the prayers are
Not
same.
mentioning that or not mentioning
Yes,
that there is another civil suit pending.
yes.
How is it going to affect the injunction or the prayer for vacation of the injunction order which has been passed?
My lord, may I kindly appreciate.
How is it connected?
Yeah,
I'm
that's
trying
why,
to figure out how.
Now, lordship, may I kindly see the entire case which we have filed. First of all, we conducted an election. of People's Party of Arunachal Pradesh. After we conduct an election and we declare the result of our party, they also, my lord, conduct an election, my lord.
So your submission is now there's another civil suit that is pending, a title suit. Anyways, I will, you come into the merits also, then that I'll look into the judgments that have been cited by you.
Yeah.
Okay, and the nature of the facts that were suppressed
Yes.
in these judgments and the allegation which is made by you that now the instant revision petition
Yes.
itself deserves to be dismissed because this fact has been suppressed, isn't it?
Yes.
So we'll have to look into the facts of the
Yes,
judgments.
that's why
cited
my
by-
lordship may kindly appreciate the case which we have filed and suit which we have filed and suit which they have filed. It has a correlation, my lord. Same subject matter, outcome of the two different elections which are in challenge in the first case and which they have challenged in the second case, my lord. Isn't it related, my lord? And against which they have come into revision before this honorable court, my lord. Whether it will have no bearing on this one, my lord. Definitely it will have, my lord. Because it touches the core of the dispute between the parties, my lord.
So in their civil revision,
Yes.
the instant civil revision is for the vacation of the stay order.
Yes.
Okay. Now, in the title suit, which you say was not mentioned before this court.
Yes.
Okay. It is not with regards to the stay of the election dated it was 2023, but it is for setting aside the election result 2022. Isn't it 11 November something, 2020?
Yes, ma'am.
The previous one. So supposing their prayer was allowed, okay, and the 2022 election result was stayed. In the meantime, in this injunction order, 2023 election has been stayed. The result, isn't it? 2023. So supposing this is not stayed and that, we'll have to see.
It will have impact, lordship. It
What
will
is the
definitely
impact?
have impact, my lord.
So your point is that you did not go into the merits, suppression of facts, and therefore the revision petitions has to be set aside.
Yes, madam. Apart from that,
Or
if this
consider-
honorable court wants that I should also submit on the merit, madam, I'm ready to submit on the merit of the case also.
This court is not going to take a decision right now.
Yes, lordship.
Okay, whether it is going to be set
Yes.
aside or not. So if you want, you can
Yes.
continue.
Yes, yes.
Not whether this court wants or not.
No.
If you
Yes.
want, you can also
Yes.
argue on the merits.
Yes.
And then on those points, I will consider.
No, lordship, if your lordship sees the civil revision petition which they have filed, my lord. The petitioner admits, my lord, in their petition itself,
In the plaint.
no, but in the plaint and
In the plaint of the plaintiff.
No, I'm sorry,
Okay,
the petitioner,
Huh.
the petitioner
Okay.
in this civil revision petition, as well as in the written statement which they have filed before the learned court below, lordship, may kindly take up the petition civil revision, page 10, madam, para 3. Page 10, madam. I'll try to cut short the matter, madam.
Page 10.
Page 10, para 3, lordship. Yes.
Wait. You see page 10,
Yes.
there's no para 3, that's.
Lordship,
why.
the civil revision petition.
Let's just take 1 minute.
Right, in initial.
Yes, yes.
Yes, Lord.
Hmm.
Now, Lordship, this is undisputed fact. The petitioner herein was elected as chairman, kindly see their own paragraph,
Yes. go
on
ahead.
22/12/2018, Lordship,
Hmm.
for session 2018 to 2021.
Hmm.
This is the categorical statement.
Yes.
The next executive election here in that same para was supposed to be held in year 2021. However, no election was conducted by the president for one reason or other, even after expiry of the tenure manner. This is the categorical statement. The tenure of the petitioner expired in 2021.
Chairman.
Yes, Lord. That is settled position, even in the written statement before this honorable court, my lord. Now, what happened, my lord? The petitioner, my lord, was a chairman. Lordship has seen 2018 to 21. My lord. What happened? During his tenure as a president, he suspended the respondent of 1 and 2 from the party.
The chairman.
Yes.
During his tenure as the chairman, not president.
Yes,
Okay.
as a chairman. Man.
Chairman.
Yeah, as a chairman, he suspended the president and general secretary against 1 and 2. Man. Then they approached the learned civil judge. Learned civil judge passed an decree in the 2000, Lordship, I'll just show you, Lordship, the decree, man. Lordship, I'll just read the smaller portion, Lordship. Page 93 of this. They have annexed one.
Page 90 of the.
This revision petition.
Okay.
They have annexed one.
Lecture 193.
Yes, madam. Now, madam, this is a order, madam, which ultimate decree is on the next, madam, is judgment is on page 95, madam. I'm not reading the entire page, madam. Some substances of that the suspension order was, madam, set aside and request, and the petitioner was directed not to, madam, permanent injunction was issued, not to issue such illegal orders, madam. This was the order passed by the civil judge. Kindly, madam, see the date on which the order was passed. Madam, page 95, madam. Lordship got it in first.
Second day of June.
Yes, 2nd day of June 2022, Lordship. And when the tenure of the chairman expired 2021.
Okay.
But the petitioner claims he is still chairman of the PPA party. Lordship is still, we as a president and this secretary general, my lord, our power was restored by this decree, my lord, of the learned civil judge. And two things are being continuously confused by the petitioner before this court. One is regarding election, my lord. Second is regarding amendment of constitution, my lord. They are two separate things, my lord. They cannot be, because they are mixing up these two together and trying to say, my lord, why you have not mentioned this amendment? It was carried on proper way. Therefore, the election is illegal. That is not the case, my lord. Yeah, by their own saying, the annexure which they have filed before this honorable court, my lord, kindly which they have Article 17, my lord.
Wait, just a second, I'm just trying to.
My lord, this constitution which they have annexed, I'm taking help of the opposite party because. Now, lordship, kindly, which they have given, lordship.
No, just come back to this judgment.
Yes, lordship.
Dated 2nd June 2022.
Yes.
What was the main issue out here? Issues where
Lordship, just
the issues.
no, it's a page 103, lordship. Order, final order, para 37. Page 103. Lordship, got it.
Yes.
The defendant, without following the procedure of Article 31, arbitrarily issued a show cause notice and suspension order dated 10/3/2019 against both the PWs. The minute of meeting dated 9/3/2019, which was the basis for issuance of suspension order, did not meet the required criteria of two-thirds majority as prescribed under Article 31 of the P Constitution. As such, both the PWs continue to remain president and secretary. At that time, this point is decided in favor of both the plaintiffs, my lord. This is us, my lord, respondent 1 and 2. The suspension removal order dated 10/3/2019 is issued against both the plaintiffs for arbitrary and against the PPA Constitution. The defendant is permanently restrained from issuing arbitrary orders without following the procedure prescribed under the PPA Constitution. This is the order.
So your position as president and general secretary was restored
Yes.
by a judgment and order dated 2nd June.
Yes.
Okay.
Yes.
Mhm.
Now,
Then,
lordship, the constitution which they are showing, my lord, may kindly see Article 17. Lordship got it. It's a page 16, lordship. No.
Yes.
Page 16, lordship. Yes.
Yes.
Article 17, lordship. Party election. Lordship got it.
Yes.
The president, lordship, kindly mark this. The president, in consultation with the state executive, shall appoint a state returning officer for the purpose of conduction party election. The president. Now, who is to conduct election? The president, lord.
Yes, okay.
Now, kindly, my lord, the Article 38, lord. Page 23. Same party election, lordship. Returning officer, 1. Kindly see this. The president, in consultation with the state executive, shall appoint a returning officer for conduction of election of the party. Rest, my lord, the state returning officer appoint a district returning officer, such and such, my lord. Rest, my lord, everything will follow. But who will, my lord, appoint the returning officer? Is the president.
Yes.
Election by the president, appointing me or returning officer who will conduct the election by the president. Now, lordship, when there was a notice from the election commission regarding the election of that one, the respondent here, being the party president, appointed a returning officer for conduction of election. Election was conducted, and the present respondent 1 and 2 were appointed as president and general secretary respectively, again with other members, executive members, by the 14/10/2023, that election. Now,
After that, with the chairman, another election was.
Yes.
held, Isn't it?
Now,
2023.
that's why madam, two things are being confused, madam.
Oh.
One thing they say, madam, he continues to be chairman, madam. Now, who will appoint the chairman?
Hmm.
I'll just lordship.
See, this has taken the better half, the whole afternoon is taken for this case, isn't it?
Yes, lordship.
The rest of the cases for today will be left over. Anyway, sir,
Now, madam,
who's going to appoint a chairman?
yes. Chairman shall be elected by People's Assembly, madam, not by this general election, madam.
Okay.
According to the Constitution, I'm just.
So this Article 29, what does it say?
29 lord. Now that's why the 29 is, my lord, has been brought into. Now this one lordship will can see 29. Now this one. Now there are two different things. That's why, madam. Now, sir, like I 29, kindly see, madam. This has nothing to do with the election, my lord. It says the party constitution shall be amended only by People's Assembly. The notice of or proposal for amending the constitution shall be given 1 month before the said assembly, madam. This prescribes how the constitution should be amended.
Okay. And you're saying that it has nothing to do with the election
No.
conducted in 2022?
No. Now,
this was before the, so you're saying that Article 17 is not an amendment, it was there from before, is it?
lordship,
Article 17 of the Constitution.
lordship, why? What is suppression, my lord? It is not a case that we have not mentioned. Now, my lord, the manner in which we brought the amendment might be wrong, might be right, my lord. That is a separate thing that can be decided in a suit only, my lord. If that is already decided, my lord, by this court or any forum, my lord, there will be nothing left before the trial court to decide, my lord. And this is not the, my lord. Now, my lord, why?
Article 7. Let's just come back to Article 17.
Now, my lord,
when was this Article 17?
Article 13, man.
Article 13.
13 is the crux. Now that's why I want to show that one. That's why. Now 13, page 14. Now, lordship may see 13, this second one. The chairman CWC-PPA shall be elected by People's Assembly in its conference of period of 3 years. And these things has been mixed up with the amendment, my lord. Because you have not stated in your plain saying that you have followed the procedure of 1 month notice. My lord, whether a plain will be drafted, we will draft the fact what we have done, my lord. Should we quote that we will have, if I said, my lord, according to this constitution, I have given 1 month notice, then we have made amendment, but that would be a factually incorrect, my lord. I will state what is true fact, my lord. What we have done, my lord. That is not a suppression of the fact before the court below.
Just explain Article 31, that point 1.
The PPA working committee shall consist of the chairman of the PPA State Council, the president, secretary general, general secretaries, 5 other members of whom 10 members will be elected by People's Assembly, and the rest shall be nominated by chairman, CWC, PPA, duly recommended by the president. This is the central working committee, how it should consist, it says. And chairman shall be elected by People's Assembly. And our election was not done by sitting a People's Assembly, madam. The president, madam, appointed a returning officer. He conducted election of the president and general secretary, other executive members, madam. Now, how the chairman is agreed by that?
Okay. So it's only in the People's Assembly, it is only the chairman.
Yes.
Not the president and
No.
this and.
No.
Okay.
Well, those things are being confused. Now, if Lordship sees the particular statement which we have made in the plain, which has been continuously shown by the petitioner here in Lordship.
Page. Page 83, is it?
Yeah, yes, but it's the plain starts with Lordship. I'll just. Yes, ma'am. Starts with page 72, Lordship.
The relevant portion will be 83, is it?
Yes, Lordship.
Oh.
Now, Lordship, page 83, Lordship. Submits that the state executive meeting was held at the PPA office, Itanagar, dated 24/9/2022, where all the signatories, like the state executive members, district president, women wing executive, and youth office bearers were present, and the House President has unanimously decided to adopt the following resolutions, my lord. On 22/4/2029, there was a meeting and a resolution was adopted, my lord, which we have annexed, my lord, that resolution. That is not suppression of the fact. Now, what resolutions were taken, that has been enumerated, my lord.
So to take away the post of
Yes,
chairman.
that resolution was passed on the date that first chairman, they pass a resolution that we will not have chairman anymore in the
And
party.
election was held in the month of October. This
Yes.
resolution was in
Yes.
the month of September.
Yes. No, my lord, here this is not an amendment, my lord. It was a resolution taken, my lord.
No, the election.
Yes,
your
election of
election
1410.
is,
Yes. 1410,
October.
lordship. And we have annexed that resolution also. Now, after that, now, lordship, whether after that, lordship will see, we have notified the election, my lord. And the returning officer, Mr. Tabat Agar, was appointed as the returning officer, and he conducted the election, my lord. Well, where is the suppression of material fact here? Now what they want, they are saying is that, why you have not said that 1 month notice was issued and thereafter this, there was an amendment, why all those things were not mentioned? That is a suppression, man. If I said that, man, then only I will be telling the lie before this court, before the learned court below, because that we have not done.
So you're saying that contents of Article 29 need not be mentioned in the plaint. I think that's it. Anything else?
No.
I'm going to make it a CAV. So give all your
Yes,
submissions.
no.
No,
Now, lordship,
Yes.
just was pointing out what about the election notification, election commission notification, all that, my lord. My lord,
yes.
they were evading why.
Okay.
evaluating that question, but I'm sure you.
Hmm.
Now.
Okay, the observation made by the Election Commission of
Yes.
India. That's one question I had asked.
Now, Lordship, can you see, my lord, page 135 of this?
Okay, this is the order of the Election Commission
Yes,
of
yes,
India.
yes, Lordship. This is important, my lord.
Hmm.
This was the case projected before the learned civil judgment. That's why the injunction order was passed.
Hmm.
Now kindly
Yes.
read, madam. The President People's Party of Arunachal, madam, such and such, the People's Party Arunachal state party in the state of Arunachal, such as, madam, this letter now, sir, I am directed to refer to a letter dated 14/10/2022. Lordship, this is the letter on which date we were elected and letter was written to the Election Commission. Date of election result, 14/10/2022. This rest letters, the earlier letters, 14/10/2022, my lord. Sergeant says, on the subject cited and state the request for change of party address has been acceded to by the competent authority, accordingly taken on commission's record, my lord. There were some said address change, my lord, that has been recorded. Further, my lord, here, this is important. In regards with update list of office bearers furnished by your letter dated 14/10/2022, my lord. Kindly mark this one. 14/2/2022, we furnished
After the election.
update.
Yes,
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 after election, the
result
executive
election.
members list were sent to the
Yes.
election commission.
Yes, yes.
Now, what the election commission wanted? It is informed that the details submitted are not in prescribed format, my lord.
Hmm.
This was the election commission's letter. Therefore, it is advised to furnish the organization election details of party along with a complete list of office bearer, members of committee, etc., elected as such election in enclosed format. The format was given. The election commission said the executive members list which you have submitted is not in the format which is issued by the election commission. So you have to submit the list of executive members in a proper format, madam. We submitted that format, our executive members. Now the petitioner makes this letter as the basis of conducting the second election. What he writes, according to the petitioner, this is a notice by election commission to hold a fresh election. Your lordship has seen, but this is the election, my lord. Now I'll just show lordship only one letter of the notification which the petitioner has issued, my lord, for conduction of the election, my lord. Two eight, lordship. 283A, lordship.
283.
Lordship, this pages, lordship.
283 is convene parties assembly for conducting party organization
No.
election.
No.
How was the second election?
Just
2023?
Lordship, yes, sir.
The rest of the matters listed today will have to be
Yes, Lordship.
left over.
I'll-
And the registry will have to fix another date.
Election matter. So that's not really urgent because all the justices doing that cannot become this matter. Because it is still 2025, that period will be over.
Item number
28, supplementary.
supplementary hearing.
Yes.
Who are the counsels for the respondents?
Yes, I am there for the petition of the
Lordship, Mr. Tiwari is not feeling well. Tomorrow it might not be possible. Seventh,
That's what my understanding.
No, but we can't have the hearing today.
No,
So 7th.
So what
It is. Yeah. Yeah.
That's what the understanding. So if that is the start of the case tomorrow, 2025.
Then when will it be available? Next date. 7th, this bench will not sit on 7th. But supposing you start and he continues, the same bench will not be.
So tomorrow we can restart.
Saying that.
This bench will not be there on the 7th.
Not be there Friday or not, it will be tomorrow. I have to tomorrow. After Friday or not, it will be here.
So he is praying for 7th. So I'll be there tomorrow. So tomorrow you give your submission. Then when will you make your submission?
He can make submission tomorrow itself.
No, because Mr. Tiwari will be here for this case. He will be leading the case.
On Wednesday,
Not when it's 7th.
7th. So that's what, you cannot have it before this bench. If it's on the 7th, you will have hear both the parties and finish it up on 7th.
Going on for a pretty long time is going on. So you have the order shape. Now he is the winning candidate. This term is for 5 years. This term is going to expire on 25.
25th, 25th.
2025. That particular 5 years are going to over. So what I
When will it be over?
2025. It's for 5 years.
So on the 7th, it's still 2024, isn't it?
But
I thought.
he enjoyed it for 5 years.
So if it is adjourned for the 7th,
It's a
7th of August,
Probably a lot of 10 minutes. 10 minutes.
whether you finish after 10 minutes or not, that's a different matter. If it cannot be heard tomorrow, the respondent cannot be heard tomorrow, and the respondent can be heard only on the 7th. This thing. Make it on the 7th when both of you are physically present, and then it's done. Because VC will most probably be in some other bench. And then hearing, the files have to be carried around, it's difficult. So make it 7th, both of you positively, hearing positively on the 7th.
I am always here. That's the whole point.
Yes.
No further adjournment should be given.
I'll note to that. Okay, yes. So let's complete this. In your case, hearing matter adjourned to 7th. So and so, please mention the names. Okay, Mr. Dev and Mr.
Saxena.
Okay, Saxena
Item
are
20.
present. Okay. On the prayer by the Lord Council for the respondent, matter is adjourned to 7th August 2020. If it may be noted that this matter has been kept pending for a long time on the adjournments paid by the learned councils for the respondent. In view of the above, no further adjournments will be granted and matter is to be heard on 7th.
My objection to the report I have.
Okay, yes.
Otherwise, that's really.
Adjournment objected by Mr. Dev. Yes. Okay. Now,
Madam,
rest will be left over.
Item number 34, we have arrived at a consensus.
Item number 25, Lordship.
2nd of August.
Here the.
Item number 34.
I'm for the respondent. he is for the-
Okay,
for the-
on the submissions made by the learned councils for both the parties, list on
22nd of August.
22nd August. August.
My lord.
August.
Sorry.
But in
22nd
respect of item of 24, my lord, in respect of item number 24, my lord, I pray that, my lord, this matter may be
Which one?
20, item 24, my
Which
lord.
it's for hearing, it's been listed for hearing.
My lord, it's in the order stage today, my lord. Item 20.
No, it's already been listed for hearing. Okay, for admission hearing. Yes, left over, left
Lordship,
over.
Lordship, item 14,
Uh,
it's an urgent matter in the sense that in April, interim order has been passed against me. And matter, the read petition itself is not maintainable. I'm for the respondent. Let this, can this matter be taken up day after tomorrow, Lordship?
Which one?
Item 14, the next item, 14.
Okay, less it will be left over. Registry will fix it.
Lordship, item number 23,
May I
I'm for
please
the
have-
respondent side. Next date may be given, and today I'll be filing a wakalat nama.
And then make it left over when it comes up, do it. No urgency.
Well, may I please your lordship.
May I please your lordship?
Lordship, at item number 19, it's a criminal petition. I'm for the private respondent. What has happened? There is this order given by this court on the last date for no coercive action, which is absolutely against the Supreme Court judgment, my lord. Because the investigation is carrying on, they're not
So
parts.
all the matters will be left over and then listed on the next date urgently, any.
So, my lord, this interim order may not be extended of this no coercive action because what has happened, the CD has received, they have received, the CD has been received. The investigation is not being able to carry on because of this no coercive action, my lord. This has to be removed because this is a direct judgment of the Supreme Court on this, that no, there should be no interference on it.
All your submissions are very important otherwise. So she'll also say something else. So listed sometime tomorrow.
No, my lord, there's
Yeah, because otherwise also we need an updated CD in that case, item number 19.
Yes, so even if the updated CD is required, even if the updated CD is required, my lord, this judgment of the Supreme Court, I brought it with me. So, my lord, but there's no coercive action, my lord.
In fact, if I may, your lordship, on the day of hearing, your lordship, Niharika infrastructure was also referred to, your lordship.
My
Lord, only that part, till returnable date, int was granted, your lordship.
No, my lord.
If they are to challenge the interim for vacating, they can file an application.
No, my lord, I am the respondent here. What has happened is this, I had filed a criminal petition. That criminal petition, the investigation is going
Okay,
on.
so when the matter is listed, we will consider. So the matter has not been, this thing was left over, any interim order will continue anyways.
My lord, but
Isn't it?
this would be absolutely against the quantum of the
Yes.
principles, my lord.
Hear you, when you're heard, then we'll see whether it's absolutely against or not, okay?
My
Now
lord,
let's continue.
my lord's own judgment from the Aizawl bench it directly says that,
Oh, whatever
yes,
it is.
under 482, no coercive action cannot be given. So I'm just praying if they have to have any kind of protection, they can go for anticipatory bail. Why are they stopping the entire investigation process?
So let's see in the next date. I don't know.
So-
I don't know because I don't know your case. I haven't heard.
So my lord, at least if time permits today, my lord, at least because.
No. It's time is almost over now. So we'll leave it list for tomorrow.
Tomorrow it will be difficult because I'm from outstation, my lord.
Then-
Then, my lord, it may be on the August.
August 12th, 12th
No, not
August.
August. My lord, it may be on 28th August.
Okay. It's written further.
Fine.
28th August. So yours is
May I-
item
may I
number
please elect-
19, my lord.
19, 28th August. Okay.
May I please your lordship? Lordship, I am mentioning item number 25, lordship. It's a hearing.
It may be taken up tomorrow after Milord Mosop.
Your lordship, in this matter, that the learned council is mentioning, your lordship, we have received the service. The service was through the PP's office, your lordship. We have received the service. However, I've checked the record. The party has not filed their wakalatnama, your lordship. This matter is for cancellation of the bail.
Wakalatnama.
No, the private respondent, your lordship.
So
We have just received the notice today, your lordship. If your lordship can fix this matter after some more days, because
No, here already LCR, everything is come.
yes.
So we'll list it tomorrow.
No,
And then we'll list it tomorrow. If you're going to pray for further date, we'll fix another date. Wakalatnama is not there.
Your Lordship, since this is a cancellation for bail, Your Lordship, the presence of other party is
Yes,
mandatory.
yes, it's
This
required.
matter
It's
we
required.
have already taken step to the private respondents also.
So it should be listed tomorrow. If the private respondent is not represented, we'll fix another date. Let's see. Maybe it will be represented also. Yes, so let's
Item-
finish.
item-
Rest will be left over. Everything. huh?
20, Your Lordship, I need to file
I'm
affidavit
for the
here, Your
petitioner,
Lordship.
Lordship.
Need 2 weeks' time, Your Lordship. Item 20.
No, all that till you leave it. That's not important. Left over whenever it's listed, you, in the meantime, you find.
Lordship.
Those are not important. Let's finish off with what we were doing because it's almost time.
May I please, my lord,
Yeah,
item
please,
number
Your Lordship.
17.
Um,
After 2 weeks, item number 17.
That, leave it. It will be listed later.
And my lord, in the earlier item number 19, interim may be continued. Highly obliged.
Let's continue.
Item number 19.
My lord, in the item number 19, the objection is, my lord. That is the entire issue, my lord. Because my lord, this item, my lord.
My lord,
here
they
is-
need to file a proper application.
What proper application, my lord? They have.
Item number 28 August.
So it's been left over and it'll be listed on the date you mentioned. Then
28
we
August.
will see, huh?
Yes.
We have already mentioned the date.
Highly
28
obliged.
August.
So this no course of action will not be reflected, my lord, because it was only till today.
No, it is not reflected. My lord,
It is
there will
there, my
be
lord.
misguiding the.
So in the next date,
the or-
whatever happens, we'll decide.
With the order is very much clear.
Continue.
My lord, the order is very much clear that it is only till today.
It will be misguiding.
It will be,
Honorable Court.
no, my lord, we follow the
28
file.
August, my lord.
I'm not passing any order. We're
My
just listing it on for the 27th.
Yes, Honor. It just-
Whatever happens, let
Yeah,
it
listed
happen.
on 28th, my lord.
I
That-
agree, my lord.
My lord.
Highly obliged.
Just leave it at that. Huh.
May it please your lordship, it's item number 24, my lord. I am praying that the similar matter has been listed on 22nd, my lord. My lord, may it be listed on 22nd of August, my lord. Item number 24,
Item number 24 on 22nd.
26. I am grateful. my lord.
Let's just make it left over, list on 22nd, item number 24.
May-
Just that.
Highly
No-
obliged.
no other-
Grateful, my lord.
Yes, okay, let's complete because it's going to be 4:30.
Now, Lordship, I'll just pointing out to the letter of the Election Commission, my lord, page 135, Lordship.
Oh,
And
that-
now,
no.
yes,
After that,
yes.
you were going to show me why
Yes.
the other election, that is 2023 election.
No,
was held.
197, Lordship.
Let's finish at least this
Yes.
matter, isn't it? 197.
Lordship,
No.
I'm sorry, 297, 297.
297. Yes.
Now, my lord, what the petitioner here, Lordship may kindly see this. This is for general information to all members of People's Assembly. Lordship may say 4/11/2023, our election was over, madam. This letter. Lordship, puts one into. This is for general information to all members of People's Assembly that there shall be People's Assembly PPA at Itanagar to discuss various policy and program party organization is election for session 23-26. Election for, Lordship may kindly say, election for session 23 to 26 November, since present office bears tenure has expired on 22nd December 2021. As per the Election Commission of India notified number, Lordship, such and such dated 18 September 2023. Lordship has already seen, what was that letter, my lord? That 18 September 2023 letter was
135, page 135.
yes, to
Yes,
submit
yes,
the,
yes,
my lord,
yes.
the office bearer's name in a proper format. That was the order, but my lord, he has twisted that order as if to conduct a new election now. Now, Lordship, may kindly the page 300. This is the extraordinary assembly minutes of meetings such and such, my Lordship. Now, what they have done, they have mentioned here, my lord. Now, Lordship, I'll just page 302, Lordship. I'll not read all due to positive time, my Lordship. The 7 last paragraph. The members of People Assembly unanimously acknowledge that letter pursued by the People's Party Organized People Election Commission of India, expiry dated 2021, and letter dated 13 September 2022, now such and such, letter dated 18 September 2023, such and such. They are quoting this letter. And the members of People Assembly resolved to conduct party organization election with immediate effect, and the People's Assembly has consensually selected Luki Boje, returning officer, RO and Sri Takam Taluka's assistant returning officer for peaceful conduction of party organization. My Lord. Where is this provision, my Lord, to conduct election? My
Hmm. Okay, so you're saying this is not as per the
No,
constitution?
no. The President Lordship, that's why I'm saying President, my Lord. The members people has accorded to declare the alleged 4th Constitutional Amendment People's Party.
Article 17.
Yes.
Hmm.
The appointment of RO members people assembly. Thereafter, returning officer proceeded to.
Yes, I've got your point.
And same day, same after the meeting, election was conducted. Now, Lordship makes see page 304. Who were elected? The petitioner Kameringo president, chairman, my Lord. Where is the provision in the constitution, my Lord, to by the RO to elect the chairman? My Lord, all these things are. My Lord, our cases, my Lord, prima facie, we have shown the court below that we have conducted election according to constitution and we were duly elected, man. That's the prima facie case, basic case which we showed before the one. That's the basic requirement also. We can't go into the entire merit of the case and the court coming to detailed merit and passing the interim order. Then in that case, the entire case would be decided, my Lord. Interim order is passed based on my Lord, prima facie case only. And we have to able to establish the prima facie case before the court below. And the court below has passed the order. When they file an application for modification of order, order 39 rule for what it says, when we lie or tell incorrect facts before the court, then only the interim order would be vacated. Where is the where we have lied in the suit, our plain? Nowhere we have lied.
Yes, so no separation.
So no separation. And in the appeal also, the appellate court has found that there was nothing wrong in passing the interim order. Now, the petitioner before this honorable court under 227 revision power. In the revision power, whether this honorable court could go into the detailed merit of the case, what's the court has to do? It has to see whether the court has exceeded its jurisdiction, where it has not exercised power which has vested with them. These two things only, rest my submission,
yes, I got your point.
Apex code and
Revision,
the revision power says, it cannot.
Three points under which revision is allowed, isn't it?
Yes.
Under 27, there are 3 points
Yes.
under which revision has to be considered,
Yes.
isn't it?
The facts and
barring
law
some,
cannot go into the detailed merit. If they but order has passed totally illegally, then only this honorable court can interfere.
Yes, authorities.
Yes, Lordship. Supreme Court, my Lord. Regarding to the Constitution of India, this is online, man. I have no time to read, so I'm referring to here in case of Chinnamal versus LR Eknath and another one. As a para 31. Let's say regarding the constitution under powers under 227, how it should be applied. Though whether I have time to read or not, only a single paragraph.
The instant this thing is under not 227, is it 227 mentioned?
It's 227.
Okay, yes.
My Lord, what I propose,
Revision.
because I'll have to reply. My Lord, it will take some time, but the time is not permit. But then your lordship, can your lordship take it tomorrow?
We can continue tomorrow instead of
It is
this.
better,
hurried
my lord,
manner-
because
matter.
reply I will take at least half an hour.
Hello,
I'm due to positive, I'm running, my little senior argued to catch, steady manner, I had to rush,
So, this is so and so, learned senior counsel, assisted by, we'll continue in the next. Actually, wait, assisted by Miss?
P.I. Bhutia.
P.I. Bhutia, learned counsel, also heard Mr. So and so. Learned counsel for respondent number 1 and 2. Okay, and Mr. R. Timo, learned counsel for, please, your name, sir, respondents number?
Except 6.
Okay. 3, 2,
If they are making new prayer, whether that order can be, hearing can be concluded, man.
no, they are going to also have something in this matter, say something, isn't it?
No, I have to reply.
Huh.
I may not file
This
Why,
one now.
why?
Now they want to file affidavit by
Not
tomorrow.
one, not that there's a
No, if
thing.
you want to file, let him file by tomorrow, man.
You are for the respondents,
Except 6.
so why didn't you file before? You should have filed your affidavit before, and now hearing is being held. We
No,
cannot
because,
make it part
If
one.
my learned friend want to file, let him file by tomorrow, no problem, because
Can you
tomorrow.
file by tomorrow? And then if he files an affidavit, will you be filing any, no,
No, we
need,
shall see to it. If it is found that it's not required, then it's okay.
Okay, we'll make it part heard first.
My lord.
Then depending on the development, we can release it from being part
Yes,
heard
sir.
and
Right,
your
right.
exercise you can do again.
Very
isn't
fine.
it? Yes, so and so. Matter is part heard, list again tomorrow.
Yes, obliged.
List
I
not
think it
so
will be
and so.
listed. my lord.
Huh.
My lord. Much obliged.
Yes, since we have taken so much trouble
Yes.
to get the matter, we'll try if the affidavit filed by respondents, the other respondents, private respondents, find that it has to be fixed on another date, then we'll use it.
Yes.